of the hearings for Brian Kohberger in the Idaho 4 murders that he is alleged to have committed these crimes against these 4 students. Yesterday, we didn't get to listen to a large portion of the hearings because they were going over the evidence stuff. Now, the defense, they've changed their mind and they want it to be open to the public. However, the judge continued having it to be closed because there's evidence that he doesn't want it to be used against, I don't know, in case there's like potential juries listening to this and they don't want to taint the potential jury pool. Now, if you guys remember, they moved from the other county and now we're in Ada County. We have a new judge that's presiding over this case. But if I was Ann Taylor, who was Kohberger's defense team, I could imagine, if she really thinks there's some really weird shit happening behind the scenes, with the FBI and the state, maybe she wants the public to be aware of it. That way, maybe it helps her case even more. It's like, hey, there's some weird shit that's happening and people think my client is guilty. However, if they knew about what I knew and all the weird stuff that's happening that, that she thinks is happening, maybe they wouldn't think that her client is guilty. But like I mentioned, the judge continued on with having it to be closed because they don't want to taint the jury pool. There's been a lot of eyes on this case. The media's been covering it and it is a very high profile case. This happened about over 2 years ago. And, we are still kind of in the dark about a lot of things. There's a lot of stuff that's been posted on the court's website. You have access to court docs and stuff like that. But still, there's a lot that we don't really know about this. And there's been gag orders and all that stuff. So just an overview of yesterday. So like I mentioned, we didn't get to listen to a portion of yesterday's hearing because it was mostly the evidence stuff. However, we did get to listen to the arguments. We started off with the motion to suppress the IgG. So that's the investigative genetic genealogy. Essentially, remember the DNA that was found in the knife sheath at the crime scene underneath, I believe it was Madison Mogan. And so that was the link they had to Brian Kohberger. Now, the issue that Ann Taylor is saying that, well, the FBI, they took over the case and it's a secret what they did. It's a secret how they were able to connect the DNA from the crime scene to Brian Kohberger. And she said that it's a secret because there's something really fucking weird going on. She's saying that maybe it was like some sort of like a violation of some sort. What she alleged, she said that what the FBI did violated DOJ's interim policy and that the FBI went through other databases that they're not supposed to in order to connect Brian Kohberger to the DNA at the crime scene. And so she was arguing, well, yes, there's DNA found at the crime scene and the action of putting the, you get like a STR profile and you put into the CODIS and then you know how they usually find like criminals through that way, right? There's like a whole database of like, criminals and stuff like that. And it's like, okay, well, they were unable to get any hits on there. So she said the FBI took it upon themselves and they were able to generate a SNP profile. Now, apparently a SNP profile is different than STR because I think STR is like short tandem repeats, right? So I think the length of the DNA that you get is like a lot shorter. Maybe you don't get as much information. However, with the SNP, I think she said that you get the whole genome. So that right there is, I guess, maybe that's more of your information. And perhaps that is something that would constitute having a warrant. I think that's what her argument was about that. Maybe I should have worn my glasses. Now I'm looking at my notes. I'm like... What does it say? So she's not saying that like, getting the DNA and then putting it to the, getting an STR profile out of it and putting it to CODIS, that's not the part where you need the warrant because that's something that's already widely done. However, when they were able to get the SNP profile, I think that's what it's called, SNP or just SNP, S&P, that process in its own, she thinks that it there should be a warrant for that. Now, there was some back and forth with her and the judge. And now, so the style of this judge, I really like him because he apparently is like an appellate judge. So the way that he operates is a lot different. You guys ever watched the Karen Reed when they were in appellate court and they were kind of going back and forth? There's a lot of, the style's like so different. So like you'll have an attorney that will present something and then the judge will ask a question, kind of like an open forum. And that's what I like about this judge. This judge doesn't just allow one attorney to go on and on and on. If he has questions, he'll interrupt them and ask them. Now that could be a bad thing because if I was an attorney and someone kept interrupting me, I'm like on a roll here. And if you keep interrupting me, well, I'm going to forget, fuck, what was I saying again? What's the argument that I was making? But I like him. I like the way he does things from an audience perspective. it's kind of nice to have someone clear certain things along the way, especially since, sometimes, you don't understand a lot of this like attorney arguments or like the jargons and stuff like that. So now what I do remember is that he had an issue with a lot of Ann Taylor's arguments. One of them was like, well, Ann Taylor was saying there's a violation, there's a violation of the policy. However, the judge was saying, well, it's not like Brian Kohberger uploaded his DNA to the ancestry.com, or I don't know. I don't remember what database it was. It's not like he was the one who uploaded the profile. It was his ancestors that did. So does Brian Kohberger, did it violated his privacy rights when it's actually just his ancestors' DNA? It's not his own DNA. So I thought that was a very interesting argument that the judge was trying to really hone in on with Ann Taylor. Now, what did the state argue? The state argued that no one has an expectation of privacy, especially when you're sharing with a company and millions of others. Again, this is uploading your DNA and then seeing if there's any matches on like Ancestry.com or whatever else there's, 23andMe and something like that. The state mentioned, I don't know who argued for the state again. Oh, it was a she, yeah. The state mentioned that policy is not law. Again, this kind of like jogged my memory a little bit with Sarah Boone with the Orange County Sheriff's Office. Remember how they were saying that like, oh, well, the detectives, they were breaking policy by not following to the T, how to ask someone the Miranda questions. And so I remember the judge saying, Judge Krenick was like, well, if they violate policy, is that a violation of someone's constitutional rights? Like that was like a back and forth between the judge and Owens. We had a case that was cited. Oh, I forgot to look it up. Oh, I should have looked it up. Okay, so Ann Taylor kept citing a case, something about Davis, right? And so the state was like, okay, well, in the Davis case, there was an investigation to a shooting. They went to the hospital. They saw clothing. It was like, apparently they saw clothing that they collected per the Plainview Doctrine. At that point, though, the victim was not a suspect, but later on, the victim did become a suspect. And they said that, well, in that case, you can't take something, you can't take stuff as like someone who's a victim, but then later on use it now against them as a suspect, right? In that part, I think you would have to get like a warrant. And so that was the Davis case that they discussed. And I wish I looked it up. I forgot. I'm sorry. I just remembered it. Something about vials and bloods being collected. I didn't look up that case. And then going back to the S&P. So apparently the people that testified, or someone that testified earlier that day, talked about the S&P. And so he said that, he's done over thousands of I guess he worked like thousands of cases or something like that, or maybe processed them thousands of times. I forgot. And he said that he was able to find medical information out of it. And what the state was really trying to talk about was, well, it's not what law enforcement could do, because maybe with the S&P, you could get medical information and a lot of information out of you. Maybe S&P is damn, you're getting a lot of personal information that maybe, as Ann Taylor is saying, maybe you do need a warrant. But again, the state was saying, well, it's not what law enforcement could do with it, but it's what they did do. And in this case, they purely just use the S&P as a means of identification, which is tying Brian Kohberger to the crime scene. And so there was a little bit of argument with the trash as well. And I think this is when they went through Brian Kohberger's parents' trash and was able to find DNA that tied to the knife sheath. I think, if I remember correctly, I think it was probably maybe the father's DNA. And they're like, okay, father's DNA matches the DNA on the knife sheath, but not in terms of matches. I'm sorry, but it's like a parental there's like a familial, there's like a term that they use, like some sort of familial DNA, when it's sort of a match, but because it's it's like a parent's DNA. And so Ann Taylor did make an argument about ordinance. So I guess there's an obviously a city ordinance where it's hey, every day put out, or not every day, once a week, put your trash out on the curb, and then a trash collector is going to come by and collect it. And so the state was trying to argue that, well, by having the parents put the trash out, they're abandoning it. And if it's abandoned, then it's fair game. Law enforcement can go through, take out what they want, and then, do the whole DNA thing. However, Ann Taylor was just saying that oh, well, the family was just following city ordinance, and, that's how you're supposed to throw trash away. And so I don't know. I don't know where she was really going with that. She brought it up, and then the argument kind of died down. And I think it was good that it did, because I'm okay, well, but they still abandoned it on the public street, right? For the trash collector to come pick it up. So I don't know. Maybe she'll get more into the argument later on. And then they talked about So again, they were arguing the motion to suppress the IgG stuff, the investigative genetic genealogy. God, what a mouthful. And then they also talked about arguments for a Frank's hearing. So the defense, they think that there was issues with, of course, the arrest affidavit. Is it an arrest affidavit? Arrest affidavit, arrest warrant? Well, the same thing. She said that there was issues. Essentially, like basically when you're trying to get a arrest warrant, right? Law enforcement, they put in their information together and then they give it to a judge. And so Ann Taylor was saying that like, well, law enforcement either intentionally or maybe with a reckless disregard for the truth, they misrepresented things. And then that led to the judge basically, allowing these like search warrants. I remember they mentioned like AT&T. There was like 2 of them. And then there was like the DNA, the car, the house, the parents' house, the apartment. And so she was essentially saying that, like, law enforcement, they either lied or they did X, Y, and Z, and they made their investigation looked a lot more promising, I guess, than it really was. And so the judge was going back and forth and saying, well, ultimately, though, let's say everything you said was correct, or let's say we took out all the stuff that, you think that they lied about. At the end of the day, there was still a DNA on the knife sheath. Wouldn't the, like the arrest affidavits and the arrest search warrants, wouldn't it still stand because of the DNA in the knife sheath that they found through IgG and blah, blah, blah. So, I mean, at some point we're kind of going in circles a little bit because Ann Taylor was also arguing, well, the IgG stuff, we think what they did was unconstitutional. And so, but that's basically where we ended yesterday. And there was a lot more. And I'm not going to lie, I did start like getting a little bit sleepy because I was like, oh, okay, a lot of these arguments are a little bit like... It was a little bit sleepy for me. I was trying to catch up. But now we're on day 2. We're on day 2. Let's see what the vibes of the judge is today, because the vibes that I was getting from the judge yesterday was that he was just really not buying Ann Taylor's arguments. However, he was, of course, letting her state things for the record, for potential appeal stuff in the future. But I think he was just kind of like losing patience a little bit because he's like, okay, like I'm not buying what you're saying, but I'm sitting here, I'm gonna have to listen to you. There were some parts where he was pushing back with the state a little bit, but I think he was just like, like slightly pushing back with the state, entertaining, certain instances and stuff like that. But I think with Ann Taylor, the pushback was really strong, in my opinion. So, and then also he has called out the defense before. I think twice already. I've heard him call out the defense for trying to argue for the cameras and not argue for him. So yeah. This judge is not playing any games. Hey, Joe. Hi, Jan. How are you doing today? How's it going? Hello, Amanda. Amanda popping in early. I saw you earlier. Hello. Betsy, the judge was so over her. It was a very weak argument. The judge was not very happy yesterday. She made a lot of claims with no evidence, in my opinion. It seems like she can't confirm her claims. Yeah, and I saw the thumbnails that Law and Crime already made where it's like, there's a part in the beginning where it was getting kind of spicy, in the beginning between the judge and Ann Taylor. And Ann Taylor's like, I think she's doing a pretty, good job. She's really patient. She's like, if I was her and I had a judge like constantly like ask me questions, like hounding me like that, dude, I would have a hard time trying to keep cool, calm, and collected. I think she did a really good job at doing that. And then like, like pushing back against the judge, but not enough to be like overly like rude or anything like that, and like trying to really like lay her foot down when she can. But, she did have some issues where the judge would be like, I remember in the very beginning, the judge was like, okay, well, what are the cases to support your argument? Because I don't see any. And she's like, well, don't really have any. And then, they get into this whole thing. And again, he's like, what are the cases? What are the cases to support your argument? And she's like, I don't really have anything at the moment. But I mean, I think a lot of the stuff that they are talking about, I think they're treading into, this whole like new advancing technological stuff. It's possible that courts are just behind on a lot of this, and maybe not yet there's cases to back her up. Maybe she will be the case that, will be case law for the future, for future decisions, stuff like that. So, because the part that I thought was really interesting to me was privacy interests when it comes to like Amazon.com, right? Can law enforcement reach out to Amazon and Apple and get all this information from them without a proper search warrant? That's a lot of information that you can get from Amazon. That's potential a lot of information you get with like Apple, right? Apple has like your tracking stuff, your health stuff, your steps, what you download. I don't know. And then Amazon's got your purchases, but Amazon's just not like a used books website store anymore. It's like, it's more than that, right? Amazon, even right now, Amazon is offering for you to refill your prescription with them, which I was thinking about. I was like, oh shit, should I do that? Because it's really archaic to get a script and then having to go to the pharmacy, wait 20 minutes, and then for you to give you their medication. It's just funny because we were just talking about this yesterday with Dennis, because I had to get it for my my teeth stuff. And then we saw the Amazon thing. She was like, oh, should I just upload my script to Amazon and then maybe they could just deliver it to me in 2 days? Like, that'd be pretty fucking awesome. But yeah, so going back to what I'm saying, like Amazon, Apple, like they can have a lot of information on you. So yeah, I don't know. And then I think one of the issues that stood out with me was I think some of the stuff did have warrants, but I think it was like the FBI had warrants for it. And then maybe the state piggyback off of it. However, I think Aunt Taylor was trying to argue that, like, no, the state should also request warrants as well and just not piggyback off the FBI. I don't know. I was trying to read, like, all the stuff that she filed last month, and I was like, ooh, this is a lot. It was really heavy. And I'm just trying to figure it all out and, just parse everything. Doing my best. But okay, so we have day 2 here. Hopefully there'll be some clarifications. Today is a lot shorter than yesterday, although yesterday, again, we didn't even get to listen to a large portion of the hearing. Today, I think it's only maybe 3 hours total, but I mean, it'll probably go by pretty quick because we're gonna have it sped up. All right, that was a long, lengthy intro, but I just want to make sure that we had all of information, together, and just a little recap of yesterday, because I know yesterday was, I was getting a little bit snoozy towards the end. All right, guys, let's get into day 2 of the hearing. Again, we're going over the motion to suppress the IGG and then arguments for the Franks hearing. I think right now we're at the arguments for the Franks hearing, which kind of interweaves with the motion to suppress IGG as well.
Your Honor. First,
Hang on a second.
oh, sorry.
I haven't called us to order
Oh,
yet.
I am so sorry. I thought you said, sorry.
I said, let's bring the public in.
Okay.
If they want to know how many USB
I
cables are by the
appreciate
year.
the eagerness, though. All right, are we broadcasting, Sandra? All right, this is continued hearing in State v. Kohberger, CR 0124316665. Defendant is again present with counsel, Ms. Taylor and Ms. Massoff. The state is present, represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. This morning's hearing will discuss the motions to suppress and any evidence related thereto, as well as we'll get into the argument on that. So with that, I understand the parties are prepared to proceed. The defense, do you have witnesses to call this morning?
We do, Your Honor. We have 2.
All right, who's your first witness?
Corporal Brett Payne.
All right, let's get going with that then. If Corporal Payne would step forward.
Corporal Brett Payne.
You were sworn yesterday, as I recall, but we'll go ahead and do it again just for formality's sake.
Good morning.
Morning.
Could you please state your name and...
Sorry, random question. Do you guys get like sun or glasses indent on your nose too? That's like permanent. How do you get rid of it? Or how do you prevent it? I don't know. I just have like a permanent indent here, so I'm trying to chill out wearing glasses, but then I feel like things are a little bit blurry here.
Spell your last for the record.
Brett Payne, last is spelled P-A-Y-N-E.
And what's your title?
I'm the Detective Corporal for Moscow Police Department.
I think he
Can you tell
before,
the
right?
court, I know you
Moscow?
testified yesterday, but it was a different hearing, and so just to lay a little bit of foundation, can you tell the court your background in law enforcement?
So I've been with Moscow Police Department for almost 7 years now. Prior to that, I was in the active duty military for 6. 3 of those were as a commissioned officer in the Military Police Corps.
What is your role in this case?
I was assigned lead detective in this particular investigation.
And so, as lead detective, can you explain from your perspective what that has meant that you have done?
Certainly. So it was my responsibility to basically view this investigation from a 30,000-foot view, if you will. Directly, it's the teams that were assigned to various tasks, and then taking all that information, synthesize it, put it back out to our group, and then eventually consolidate it into an affidavit.
Hello.
And in terms of that affidavit, yesterday there was some discussion and testimony about that and how it was created. Would you explain that?
Absolutely. So the information was brought to us via various teams and specialists in their particular areas. For instance, most of the cell phone stuff was covered by Special Agent Balance from the FBI. All that information was brought to the team, relayed back out at least twice a day, and then as that information was essentially synthesized, it was put into a running document, a living document that is now known as Exhibit A.
So when it was characterized yesterday as a group effort, do you agree with that characterization of it?
Yes, ma'am.
And do you know approximately how many warrants you worked on in this case?
I don't, ma'am. Several. I don't know the exact number.
Right. I'm going to walk you through several segments of different warrants, and some of this may seem choppy, but I'm going to try to do you and then Detective Mowry at once instead of bringing you back and forth.
I have not seen this yet. No, I'm watching it for the first time with you guys. Dude, I was watching a bunch of Blake Lively, Justin Baldoni, It Ends With Us interviews this morning. So I'm watching this with you guys, and then I was thinking about maybe putting a video about all the interviews that I was watching about that, but yeah.
Does that make sense?
Yes, ma'am. Sounds good.
All right. And Judge, I have paper exhibits for you and for the witness. And so I'll go as fast as I can, but I want you to be able to look at what he's looking at. So we're going to begin with the first AT&T warrant. AT&T warrant.
No, ma'am. I don't believe I had.
And so given that, who did you rely on in creating the warrant? For
Largely
AT&T?
Special Agent Balance. Obviously, he's the CAS expert, so I rely heavily on his input.
FBI?
At the time that AT&T warrant 1 was secured, were you co-located with Special Agent Balance?
I believe so, yes.
Can you, well, in terms of being more specific, it was December 23rd. Were you two co-located at that time?
I believe so, yes.
And I know co-located has been talked about in court a couple of times, but can you just explain what it means for you two to be co-located since he's from D.C.?
Yes,
Certainly.
explain.
Yeah, he was in the same building as I was, just mere feet away from the command post.
Okay, so when you say mere feet away, were you guys in like a cubicle setting, or were you in offices with doors? What was this setting in terms of proximity to each other a few feet away?
Yeah, separate offices with doors, but in the same second floor of the Moscow Police Department.
Are you aware of Special Agent Balance in his work in doing AT&T records having any access to AT&T records without a warrant?
I'm not aware of that, no.
Are you aware of him having any ability to review AT&T records through any portal without a warrant?
Not to my knowledge, no.
Bag bomb? Moisturizer? Oh, it doesn't slip.
I'm going to begin with what is known as State's Exhibit 1, attached to their objection to the motion to suppress AT&T warrant. And Judge, for today's purposes, what I'm doing is relying on the labels that are in the record as opposed to giving them new stickers.
Hey, princess.
It's been marked previously as State's S1, or is that 8-1? I can't.
I think it's SS for State 1.
All right, State's S1 affidavit for search warrant.
Hey,
No,
Samurai.
I've got it.
Objection to the admission of that for today's hearing.
You know, Judge, I should have started out by saying that the same stipulation regarding the admission of all exhibits applies today.
Hey, Wigu.
We do need the formality of moving for their admission, however. So that's why.
I can do that. Do you want me to do that per exhibit?
Well, it makes, as you're talking about them, a couple makes sense.
Okay, I've got to get myself S1. Look at page, on page 5 in the sentence above wherefore that begins with the paragraph. It begins in support. Can you read that paragraph?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
And is that S1 the affidavit in support of the search warrant?
Yes, it is.
And that's the AT&T 1 search warrant that was the first one served on December 23rd, correct?
That's correct.
And that language that you put in there, Exhibit A, is incorporated as though fully set forth herein. Is that the language you just read?
Yes, ma'am.
Personal knowledge?
All right, I'm now going to hand you State's Exhibit 2 to the AT&T first warrant. Can you review that first page, the first paragraph?
Of S2.
Pardon?
Are you seeking the admission of S2?
I am seeking the admission of S2. Just to be clear, Judge, all of these that I'm putting before him and the ones that are attached, we're seeking the admission of.
No objection to S2? All right, submitted.
Have you reviewed that, Detective Payne? Do you see that, the language that I just referred to in the search warrant affidavit, do you see that same language in this warrant where you incorporate the affidavit, incorporate Exhibit A into your, you see that language
Ma'am.
in S2? And is S2 the actual search warrant for AT&T?
Yes, ma'am, it is.
Can you turn to the last page on page 4? What time was the warrant served?
10:03 a.m.
Do you recall that the return on that warrant came in at 3:30 that day?
That would sound correct. I don't remember specifically.
Would it help if I showed you the AT&T mobility provided front page to verify?
Yes, ma'am.
Judge, I'm not seeking the admission of this, just for purposes of him being able to be certain. Sorry.
Witness may be shown to refresh his recollection.
Refresh.
Yes, sir. And Judge, remember, this has also been admitted already in Frank's D17, page 634. Detective, can you see on that that came in at, I think it's 15:30? It's
15:31.
okay. Thank you.
So I'm speeding through the parts where they're just doing like nothing.
I'm now
Yeah.
having you defense exhibit A to the reply to the AT&T suppression motion.
Is there not a sticker on it? This does not. We have a sticker on it.
No, it is not, but it is attached to the reply as exhibit A, AT&T. And that reply is, okay. Can you see line 4 there? Oh, sorry, Judge.
Copy and put, let's just, do you have a number that we were going to call this?
I would call it exhibit A to reply, because that's what it is in the record. You see at the bottom of the page where it says exhibit A, AT&T?
This is the return of the warrant of S2.
I'm just speeding
Yes.
through this.
Let's call it S2.2, or 2.1, pardon me.
Okay.
Practice associated with that particular warrant.
I want to see the judge getting impatient with the defense. I want to see the judge getting impatient with the defense at this hearing. I realize it's a very different
Page
style.
2 of that exhibit A. It's actually just the front page where it says affidavit of pain. What does paragraph 4 say?
Paragraph 4, line 4.
Line 4.
It says the warrant was served on 12/23/2022 by email, fax, etc.
So do you know exactly what method was used?
I don't remember.
Okay. And it says warrant in that line, right?
Yes, ma'am.
Does it say anything about the affidavit in support of search warrant accompanying the warrant?
Oh, ma'am.
Hi, lady.
On the next page, the receipt and inventory of warrant, do you see that?
Yes, ma'am.
Can you look at description of property? What does that say?
It says 509-592-8458.
Can you explain how that's a description of property and what that means?
Phone
It
number?
just means essentially that there was the information retrieved as a result of that phone number being queried with AT&T.
And it indicates that that was produced how?
Entrance was obtained by email.
And when that was received, did you do anything to verify that the data was within the date ranges of November 12th to November 14th of 2022?
I don't remember. That information was provided to Special Agent Balance as soon as it was received.
Do you have, when you say that it was provided to Special Agent Balance, is that because you don't have the capacity, technical skills, I guess, to review that raw data and do something with it?
Yes, ma'am.
Was there anybody else that you relied on for that other than Special Agent Balance?
Not that memory brings to mind.
Okay. Let's now turn to the AT&T 2, pen trap and also known as pen trap and trace. Can you explain what a pen trap and trace is?
So, pen register, best of my knowledge, now granted, as I've stated before, I'm not an expert in cell phone stuff, but to the best of my knowledge, a pen register tracks incoming and outgoing phone calls, text messages, so on and so forth. And then the trap and trace is the portion that essentially gives you location data, or the precision location data rather. So it's essentially incoming and outgoing calls, what messages are received, and then part of that was where that phone was located when it was doing it.
Was it required that you secure the AT&T first warrant to obtain the second warrant that included a pen trap and trace?
I don't believe it was required.
So when the data was received on at 3:30, you gave that data was given to Special Agent Balance?
Yes, ma'am.
Okay. And then what happened in between 3:30 and 4:53 when the second warrant was?
And to be clear, the pen register and the trap and trace, they don't record phone calls. We just have the numbers that were dialed, and then he said the trap and trace is when there's like incoming, outgoing calls, and then like the location where you were at that time. Maybe this even shows like duration of the calls, but I don't know if it shows if a call was successfully made or not.
Secured.
Are you talking technically speaking, or can I speak in generalities? Because that's all I really know.
Well, I want you to talk about what you know.
So the only thing I know is that that information was provided to Special Agent Balance. He utilized whatever tools he has at his disposal, and then it was decided upon to go after the second pen trap and trace.
When did you start drafting that second trap and trace?
I don't remember.
So on that day, you did one in the morning that was secured at 10:03.
Yes, ma'am.
And then the second one was secured at 4:53 p.m. And you
Okay, here's the crazy thing. I thought generalities was a word that I made up. And so I remember I was like, oh, I need to stop saying that word. I feel like I just like made that word up. But then afterwards, I started hearing people using it. So I was like, oh, maybe it is a word. I always like second guess myself.
don't have a recollection of when you were working on those.
I don't remember, no.
It sounds like like a made-up code word.
All right. I think you have State's Exhibit 2 in front of you.
Yes, ma'am.
Can you flip back to that one? Can you see on page 1, what does it say that the time of that warrant was obtained?
I know State's Exhibit 2. No, 1003 is what it says. Is that what you're referring to?
No, I'm referring to the return, which should be in, I might be referring you to the wrong exhibit.
1, I believe.
And that was at 453. The second warrant was obtained at 453. I might not have handed you pen
I
trap.
don't think I have that one.
So I guess warrant return and warrant obtain is the same thing.
Yeah, my understanding is, just so we're clear, because I'm getting a little confused, is that we have the affidavit warrant, the warrant, and the return of the warrant all related to the first warrant to AT&T. And we haven't got the pin trap and trace warrant presented yet, I don't think.
Right, I've got it here. And Judge, for clarification purposes too, today as we're going through testimony, my plan was not to go through every single warrant that we're arguing about and get it in front of the court. I'm really trying to take kind of a scalpel approach on the issues that we want to point out to the court. So it does really feel like I'm jumping around, and I realize that. I hope to bring it all together in the end.
The only caveat being what I told you
Okay, good. Because I was like, man, because they have a lot of warrants to be going through.
before is where you have is a broad array of documentation that you've presented. The court will not scour the record to find support for your motions that's not pointed out to the court specifically. And that's well established with case law in the Idaho Supreme Court.
And Judge, that's why I am trying to grab the pieces and parts that I want you to be able to identify, and that's why I'm putting the paper in front of you. So I'm hearing you when you've asked us to do that.
Did he make that argument previously? Was it in this court or was it in a different courtroom? I remember a judge accusing the defense of not pinpointing parts that support their argument. And I remember the judge saying, I'm not going to go through and find supports for your argument for you. Was that for this case or was that for a different case? I don't know, I just got like a random like memory like bloop. Hi, Schubert. Happy New Year. Hello. How's it going? Hello, hello.
All right, I'm handing you State's Exhibit 1. And this is to the second AT&T warrant, also known as Pen, Trap, and Trace.
This one is also listed as S1 on the sticker. So that's going to cause some problem, I suppose.
It's S1 attached to a different motion to suppress.
Well, hopefully we can figure it out when we're looking at the entire record. But
And what I think, Judge, when you are going back and working with your clerk.
my concern, frankly, I know what all the documents are and what they relate to.
Yeah.
My concern is a reviewing court's ability to understand what you're talking about in court today and trace it to a stack of documents. That's my concern for this. So.
And I understand that. And so in preparation for today, I mean, I really did think, do I need to go through and label all of these? And I thought that would create more confusion in the record because these are all attached to specific motions with these labels.
This is marked S1, titled Affidavit for Search Warrant and Application for an Order for Pen Register or a Trap and Trace Device.
Yes.
So you're on the record what we're looking at.
So Detective Payne, is that the warrant that affidavit in support of the search warrant that you drafted for that second AT&T warrant?
Yes, ma'am.
On page 11, at the bottom of the page, can you read that last sentence under probable cause?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of the affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
All right, I am now handing you S2, which is the search warrant and order authorizing installation and or use of pen register trap and trace device and non-disclosure order pursuant to Idaho Code 18-6772.
Okay, you received it.
Can you please turn to page 7? Can you see what time that was obtained?
4:53 p.m.
It's all good, Anne. It's all good. I thought a lot was was one word for a long time. I think I realized a lot was not one word in think mid-20s. Because whenever you would write on, what's it called? Like Microsoft Word or something like that, you would get that weird squiggly thing. I'm like, why the fuck does this thing keep popping up? I didn't realize Till was spelled with like one L. Oh, it's all good. It's all good. Hi, Bleep. I like that color, Bleep.
I'm now handing you what is titled Return of Search Warrant, Exhibit A to Trap and Trace.
Is that a sticker on it?
Pardon?
Is that a sticker on it?
No, it is not.
No sticker?
It's 2.2.
What do you call that, Judge?
S-2.2,
S-2.2.
further delineated by the title, which is related to the trap and trace.
Hey, just forwarding through this.
On page, can you look at page 2? You see the top, who does it say it's the affidavit of?
Corporal Brett Payne.
Are you looking at Exhibit A, page 2?
Oh, correction. I see what you mean. Affidavit of Lawrence Mowry is what it says at the top.
Right, and then, but is that actually your
It is. Yes, ma'am.
affidavit? And so that was a mistake.
Yes, ma'am.
I'm sorry, what were you looking at?
On page 2, the top of it says affidavit of Lawrence Mowry.
Oh, gotcha.
It's the affidavit of Corporal Payne.
A heading problem there.
I'm now handing you Exhibit C to the reply to Trap and Trace. It does not have a sticker, and it says AT&T Mobility Carrier Request Form.
This again relates to the trap and trace warrant.
It does.
Let's mark that S2.3.
Anyone here also a finger licker when shuffling through papers? I just saw her do it just now. I'm like, ooh. Did you get hacked? Ew. Not used to getting compliments from you.
In the next day or so, if you would provide a formal identification list, if you will, of the exhibits that you'd stipulated to admission to yesterday, as I don't think we went through those individually, just so that there's a record of that.
We can do that. Might take us a couple days, but we can do that. Can you look at, are you looking at that Exhibit C, Detective? Was cell site location data requested for this warrant
Stop insulting Jan. That's so fucked up, Bleep.
on this page?
Yes, ma'am.
And was a timing advance report requested on this page? I'll refer you to the last paragraph where it says remark special instructions.
Yes, ma'am.
Till with two
And do you
L's
see
is,
any
till with two L's is like a farming word, right? I think like where you're like tilling the land. Hey, Brian, how's it going? Hello, hello. Hi, Corgi. Hi, everyone. What's up, Brian?
reference in this document indicating that the affidavit in support of search warrant was included with the warrant?
No, ma'am.
Okay, the next warrant I want to talk about is Apple.
Hey, Apple. I hate finger-licking page turners. I read a lot of library, but this is my worst nightmare. Dude, the worst one was finding a giant fucking booger smack dab in the middle of a page. Dude, I couldn't get books from the library for like years. Oh god, it was so bad.
Prior to this case, had you ever prepared an Apple warrant?
I don't remember.
What was your training related to Apple warrants in December of 2022?
I had no official training at that time.
I'm handing you what's been marked as Defendant's Exhibit A. It does have a sticker, and it's to the Apple motion.
Hey, Gigi. Ew, fire. Oh, gross. I think someone did that to my eraser. They would bite. Oh, yeah, they would bite the erasers, right?
Can you state what that document is?
It appears to be a preservation request.
And who is it sent to?
Apple Corporate Legal Counsel,
And what's its date? What is it? What is the date on it?
December 21st.
Of 2022.
Correct.
And that letter was not sent by you, right?
No, I do not remember sending this, no.
Yeah. Well, can you look at the
That's not me.
yeah, the top of it is Department of Justice, and the back, page 2 is Special Agent in Charge Dennis Rice.
Correct.
How was the DeSales email account known at that date?
I don't remember.
How did you become aware of an Apple product in this case?
Memory serves, when the search warrant in Pennsylvania was executed, there was an iPad that was located in one of the shared living spaces in the home, and there was a receipt in his vehicle, in Mr. Kohberger's vehicle, that was found for an iPad as well.
And during the home search, was the iPad seized?
It was not.
Why not?
It was in a shared living space.
Do you remember what day that the Apple account was created?
I don't remember. No, ma'am.
Does 2016 sound familiar with the research?
That sounds vaguely familiar. Yep.
And you mentioned the receipt that was found in his car. Do you recall the
2016, okay.
an Apple product was purchased?
I do not remember.
Right, I will show you State's Exhibit 1.
You know what? I think I read this argument about the Apple email and all the other email addresses in all the motions that were filed in December. Just jogged my memory
To the
a little bit.
affidavit for search warrant.
Hi, Christine.
And I believe it's tabbed, the receipt.
This is State's Exhibit S1, affidavit for search warrant to Apple Inc.
And it's 2018, the date.
Yes, ma'am.
Where did you get the form to prepare the Apple warrant?
The form? Be more specific?
Correct. Well, the search, so you're looking at the search warrant affidavit, and inside of that affidavit is a long list of items that you request.
Yes, ma'am.
Now, this is me being impatient and thinking ahead of it here. Are they trying to say that this officer doesn't have specific training, doesn't know anything about like Apple warrant related stuff, whatever? However, the special agent does. The special agent that works for the FBI. Did the special agent who worked for the FBI, did he do something that he wasn't supposed to do? And then somehow was able to generate this Apple email address, maybe? Is that where they're going with this? I'm being impatient.
Where did you get that information to be able to include that?
That was all provided to me from the experts in that particular field.
I'm just getting S1 in front of myself for a minute here, Judge, so or I'm going to have to give them a different exhibit.
Just so I'm clear, when you said the long list, are you referring to paragraph B on page 2?
On page 2, beginning on page 2,
Is that what you're referring to?
I'm referring to everything A through I.
I'm sorry, was there a question pending? I kind of threw us down a side alley there, so I apologize if there was a question pending that I threw you off from.
No, that's fine. I'm looking for the page here.
Is there any actual proof?
Do you recall that in your affidavit?
Any actual proof that Kohberger is guilty? I mean, the strongest so far that the public knows about is the DNA that was left on the knife sheath. The cell phone stuff, remember how we read the arrest affidavit and it seems like the cell phone stuff correlated with some of the weird shit that he was doing? There was a hearing or a couple hearings that happened a couple months back, or was it over a year? It's been a long time, where maybe the cell phone related stuff is not as reliable as how the police described in their arrest affidavit. Because I remember when we were reading the arrest affidavit, we're like, oh wow, this is some strong evidence against him. But then there was like some cell phone stuff that was happening in a couple hearings a while back where, maybe the cell phone evidence is not as strong as how the law enforcement purported. So we'll see.
There's reference that iOS devices can use an iCloud account to back up the iOS device.
Yes, ma'am. That sounds familiar.
And what's your understanding when an iOS device uses an iCloud to back it up?
Similar to Google and many other of these digital operating systems. Essentially, they back it up to a cloud account. So that information is stored not on your device only, but also in a cloud storage area. That's my understanding of it.
And so in an Apple phone, that ends up as creating a duplication of what's on the phone?
Essentially, yes.
Oh, was it in May? Wow. May 23rd, 2024 and May 30th, 2024 motion to compel hearing about the cell phone information. Yeah, because I remember hearing that, and we had a cell phone expert go up there and testified. Geez. Did I listen to the whole thing though? Or did I listen to a recap of it? I don't remember. But my impression from what I remember is that the cell phone stuff seems possibly weak. Brian Bradley, thank you so much for the 1999 message with sending my deepest prayers to you and you stay safe away from the fires. Prayers to everyone in LA. I think I saw a news fire may have sparked up right by a highway. Just crazy. But luckily, now we're pretty far from it. But before, when the Eaton fires were happening, yeah, I was getting really fucking nervous. Getting really nervous. Yeah, let me see. Yeah, it was like the Sepulveda fire, but I think that's been put out. That's the one that was like, I saw videos of it. It was like right next to a highway, crazy, like cars driving by, and there's like a fire like flaring up. I think the new fire was the Hughes fire, but they've been doing pretty good at containing that, it seems. Was it the Hughes fire? Yeah. Oh, but there's a new fire now. There's a Laguna fire. I mean, I don't know. I've only been living in Los Angeles for 8 years. Do fires just happen very often and it's just not? Maybe it was reported and I just wasn't paying attention to it. But I knew that there was like fires happening in like Malibu, here and there. But like now there's just like all these like fires just like popping up. I'm like, what's going on here? Are people starting the fires, or is it just like, I don't know, the sun, the wind? I mean, it's warm right now, but it's not like super hot outside. Is it telephone lines? Like, I don't know. Like, what's going on here? Fire in California, Texas snowing. Yeah, my sister told me it was freezing in Texas, but I think now it's back to 50s or something. I don't know. Wild. In this case, the FBI did everything and gave the MPD zero proof of anything. They obtained warrants using false information, searched databases illegally, made statements with no evidence to back it up. Fire in California, Texas, crazy months. I mean, okay, here's my theory. My theory is that all this is my fault because I'm a very unlucky person. It is the year of the snake, okay? And whenever my mom tells me that, oh, this is going to be your lucky year, or this was your lucky like birth month, or blah, 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 something always happens, okay? I was like telling Dennis, I was like, man, Dennis, like 2023 or 25, it's going to be a weird year. It's going to be a weird year, you know? Year of the snake. I'm just a very unlucky person. So that's just me just talking nonsense. But I don't know. I was telling Dennis, like, you know, it's going to be a rough year this year. Buckle up. I'm a very unlucky person. The cell phone expert for the defense testified May 30th after Officer Payne testified and Officer Maurer testified on May 23rd, 2025. He wasn't available until, the 30th. Okay. Yeah, because I do remember. Maybe I should rewatch it. I don't know if I want to. Have you heard about the cult of Odin being involved in this case? No, I have not. Not in this case. For the Richard Allen case, yes, but not this one.
And do you recall that in the affidavit you made reference to the fact that Apple users get 5 gigabytes typically of storage and then can purchase more?
Yes, ma'am.
D. I'm handing you what's been marked as Exhibit D it's Defendant's Exhibit D to the Apple Memorandum in Support of Suppression, and it is it does have a sticker.
I'm looking up the till thing.
Right, it's marked Defendant's Exhibit D, date 11/14/24, entitled Affidavit for Search Warrant, directed to Apple Inc.
Can you please turn to page 27?
I'm addicted, Jed.
The actual warrant itself, sure.
Yes.
Yes, ma'am.
Well, I don't want to answer that as yes before I look and make sure what this exhibit is.
I want to make sure because my page number's run out 25.
I'm just speaking through
It's
this.
Exhibit A, and it's to the Apple warrant. It says, so Exhibit D, Apple, on that page says page 27, but above that it says page 23.
On there.
Okay. At the top, it says on January 27th, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records.
I'm not there, so can you?
Oh, I'm
please
sorry.
direction it? Are we looking at state?
Exhibit D?
D.
Yeah, page 27 of my marking bait. So it says Exhibit D dash Apple dash page 27.
On January 27, 2023?
Yes.
All right, go
Yes.
ahead.
On January 27, 2023, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records. Can you explain what Apple responded to?
I don't remember what all they responded to. They responded to the search warrant and all those listed items that were in the warrant itself.
Okay. And the warrant, the date on this, if you will turn to, let's see.
Oh, you're a rabbit?
Turn to page 34 of the exhibit.
I think my brother's a rabbit.
Do
No.
you see the date of the warrant?
1st of August.
So I understand that you just said you don't know or you don't remember, but in this context, in your search warrant affidavit, you make reference to something being produced on January 27th to process to get a warrant on August 1st. Do you know what the process was that Apple responded to or what they produced?
I do not remember. No, ma'am.
I'm handing you Defendant's Exhibit B to the Apple. It's Defendant's Memorandum in Support. It does have a sticker on it.
Hey, Michael Pickle.
All right, the exhibit, just for the record, is Defendant's Exhibit B, date 11/14/24 on the sticker, and the title is Certification of Apple Inc., Custodian of Records.
Detective Payne, on this, there's a certification. This document is a certification of Apple Inc., Custodian of Records. Do you see that?
Yes, ma'am.
And it indicates that records are certified and being produced from legal process served on to Apple on January 12th, 2023.
Yes, ma'am.
You see that? What was served as legal process on Apple on January 12th, 2023?
I don't remember.
You know what the legal process would be?
I don't remember what that would have been.
Going back to Exhibit D. Do you have that one in front of you still?
Yes, ma'am.
Can you turn to page 35 of that?
Yep.
On line 4, what does it say?
Warrant was served by Corporal Payne on August 1st, 2023 via lawenforcement@apple.com.
And so that would have been the Apple warrant, right?
Correct.
And you served it, right?
I believe so.
Well, when you say you believe so, would you have executed an affidavit if you hadn't?
No, ma'am. I just want to make sure on the warrant return itself that it wasn't served by one of the digital forensics folks.
This affidavit is your affidavit, and on line 4 it says you served it, right?
Yes, ma'am.
Did you serve that with a copy of the search warrant affidavit?
No, ma'am.
Was it your practice in serving all of these warrants where you actually did service, that you would serve the warrant only?
Yes, ma'am.
Hey, Shabana, how are you doing today?
And then on Exhibit D, page 37,
Okay.
at the bottom where it says description of property, can you explain what the return was for that Apple warrant?
All account information associated data for the following Apple identifiers, and it goes through DSID, Apple ID, Kohberger at spartan.northampton.edu, another DSID, and Apple ID, Wi-Fi Armiones at yahoo.com.
Did you open up the Apple data and examine that?
I don't remember if I looked at what the return, like all the files that were attached were.
In terms of evaluating that Apple data, as the lead investigator, who have you put in charge of evaluating Apple data?
I relied on the specialists in those fields, which would be Detective Mowry and then S.A. Balance. Those are the folks who knew far more about it than me.
And do you know, as we sit here today, whose job it is to evaluate the Apple data for this case?
I don't know, ma'am. Not right now.
Okay, the next warrant we will talk about is Google.
We have AT&T, AT&T 2, Apple warrant.
I'm handing you what's being marked as Defendants D to the Google memorandum in support of suppression.
Right, so that I'm clear and the record's clear, this is Defendant's Exhibit Number D with the date on the sticker of 11/14/24, which refers to the sticker date, I believe, not necessarily the document date, and then it's entitled Return of Search Warrant, the warrant being with respect to the application of search warrant for Google LLC.
Hey, Full Truth. What's up?
That as the other documents that were proffered are admitted.
Oh, Joe. Joe, I saw your comment when I was editing my video. I wish I saw before. When we were talking about the Blake Lively and Leighton Meester, the cage comment. I wish I saw your comment. We should have watched it together on stream.
Did you prepare the Google warrant returns Exhibit D?
Yes, ma'am.
On page 2 of that exhibit, does your affidavit say Detective Mowry served the warrant through a portal?
Yes, ma'am.
How did you know that?
She told me that.
When did you get the return? When you got the return, did you review the data?
I did not, ma'am.
Did you take any steps to see if the return conformed to the warrant?
I did not look at the technical data it contained within. I believe it was a zip file that was downloaded from Google, if memory serves me correctly. I downloaded it and made sure that that was there.
And do you recall that there were actually 3 Google warrants? Does that sound familiar? I'm going to hand you now Defendant's Exhibit E. Defendant's Exhibit E to Google memorandum in support of motion to suppress.
All right, Defendant's Exhibit Number E, again with the date on the sticker 11/14/24. This is a receipt and inventory of warrant to Google.
On this document under the description of property, can you state what Google account you put in as received?
Zip files for all digital records for the Google accounts of brianchristopher@gmail.com and username spelled a bit different at gmail.com.
Did you know that the email in the warrant is actually brianchristopher1994@gmail.com?
Oh, that sounds familiar, yes, ma'am.
Okay, so on that description, is that a mistake?
Yes, ma'am.
And did you do anything to, I asked you this, but you didn't do anything to verify that the data that you received from Google fit what was requested in the warrant?
No, ma'am, not to my recollection.
Right, that's it for Google. You were in Pennsylvania for Mr. Kohberger's arrest, correct?
Yes, ma'am.
And you watched the preparation for service of the arrest warrant?
How do you mean?
Well, maybe I should ask this more open-ended. Tell us about your arrival in Pennsylvania in time-wise to his arrest, time frame of his arrest.
I believe we arrived there, if memory serves, about 7 p.m. on the 29th. And I think I get my dates right here. We observed final preparations for the SRT operation that was going to take place. And then we, myself, and Detective Gilbertson from ISP, drove to a separate Pennsylvania State Police barracks to await the arrival of Mr. Kohberger.
When you were observing preparations, what were you observing?
I believe we observed their final tactical brief for SRT, and that was about it.
Can you explain what the preparations were that they were making when they were doing that tactical brief?
I can give you a general overview, as best I got. So it had their entire SRT that was going to be conducting the operation present.
For the record, SRT is
A special response team, usually what it stands for, Your Honor. So they were doing their final preparations, going over their approach, team member assignments, so on and so forth. This was all done via basically a briefing in front of everybody.
And do you recall that the preparations included that in preparation they were going to knock and announce in execution
I believe that was brought up, yes, ma'am.
of the warrant? Okay. And while you were there, did you go into and were you given a tour, or did you drive into the gated community of Mr. Kohberger and see where he was living?
No, ma'am.
You never went in or around his home?
No, ma'am.
I remember the defense making their argument about the issue with they had with law enforcement, how they busted into the parents' house in like the middle of the night or something like that, when they could have just done it during the daytime. They could have just knocked and something like that.
When the execution of the arrest was happening, did you have the ability to listen in any way?
The only ability that we had at the time was a very choppy drone feed. We were driving at the time it happened, and that was the only communication we had.
And so how is that choppy drone feed being communicated to you?
Via cell phone.
So can you explain that? Like, who's the person communicating with you about the drone? I just don't understand.
So essentially, it's a drone operator with their SRT. I don't remember how it was conveyed, a link of some sort. They dropped a drone, it took off. I got the link so we could essentially just watch a live feed of what the drone was seeing, and that was it.
Do you know if that live feed was recorded?
I do not know, ma'am.
Did you record the while that was happening? Did you create a recording?
No, ma'am.
What is a Bearcat?
Bearcat's an armored vehicle used in SWAT operations.
And do you know what role the Bearcat? Describe that vehicle again.
So they're usually built on, I think it's like a Ford F-250 chassis. So it's a pickup cab essentially, but it's got a large box compartment in the back, for lack of a better term. Usually has portholes on the sides. It's highly up armored to protect the occupants, being SWAT operators, and they usually use them as an approach vehicle. So they have a covered location to deploy from.
Is it a like a retrofitted military piece of machinery?
No, ma'am.
It's specifically a law enforcement piece of machinery.
Yes, ma'am.
And it sounds like it's really big.
It depends on what you're comparing it to. I'd say it's no bigger than if you were to have a pickup camper on the back of an F-250, something like that.
And what's your understanding of where that Bearcat was parked for the arrest?
I believe the Bearcat, if memory serves, drove up the driveway and just parked in front of the house.
I searched Bearcat and I got this cute little slothy looking animal thing. Oh my god, it's so cute. It looks like a sloth. I think this is what a Bearcat is. Hold on. This right here, maybe? This vehicle? Look at this animal. This right here, Bearcat. Cutie pie.
I'm handing you what's been marked as State's Exhibit 5 to the motion to suppress, and it was attached to 119 Lambsden.
Okay, fast forward.
This is Mark with Exhibit 5, held document of the State Police, heading with just a letter directed to Detective Payne.
Detective, can you explain what that letter is?
As a justification for reasoning for amending the original plan for not announced to a hasty not announced and quicker entry into the Kohberger home.
Sorry.
Payne.
Detective Payne, can you explain what that letter is?
As a justification for reasoning for amending the original plan for not announced to a hasty not announced and quicker entry into the Kohberger home.
When did you receive that?
I believe this was recently. I don't remember what date.
When you say recently, was it received in response to prepare for today's suppression hearing?
I believe so.
Do you know why Mr. Lang didn't date the letter?
I have to ask him, ma'am.
Can you just fast forward to the verdict? What I got, a time machine or something? Here, we'll start a GoFundMe for a time machine. Okay, I'll just fast forward to the verdict. Fuck all this shit. Hey, beautiful messy ball, how are you doing today? Hi, Corgi. I watched Walt with EDB, but this attorney put me to sleep. Yeah, it's just a lot of like paper shuffling and stuff like that. And I'm sure at the end she'll have it all wrapped up and bam, ba-boom for us.
And so in that correspondence, he explains that the knock and announce was shortened to announcing from the Bearcat with immediate forced entry.
Yes, ma'am.
Were you present when Detective Gilbert Mirandized Mr. Kohberger at the station?
Detective Gilbertson?
Gilbertson, sorry, yes.
Yes, ma'am.
And that took place after Mr. Kohberger was first seized in his home, right?
Correct.
That also took place after he was transported in the back of a police car to the station, right? You noted in your report that Detective Gilbertson had a recorder in his pocket at the time of the interview.
I believe so.
Were there any recordings that took place at the Kohberger home when entry was made into the house?
I do not know.
Where was Mr. Kohberger's car parked at the time of his arrest?
It was in the garage.
Was it later seized pursuant to a search warrant from that garage?
Yes, ma'am.
And when you said that the iPad receipt was found in the car, is that the car that you're referring to?
Yes, ma'am.
That is all the questions that I have for you. Thank you.
Sorry, car was in the driveway.
Or is that the car that you're referring to?
Car was in the driveway, receiver's in the car. Okay.
Yes, ma'am.
Cross-exception. We have just a moment, Your Honor.
Car. Oops, wrong pen. Car. Driveway. Receipt. And car.
The state doesn't have any clarification for this witness.
All right, thank you, Detective. Step down. Actually, if you don't mind, I actually have a question.
Of course.
Oh, he has
You
questions.
testified that you didn't send the affidavits and support search warrants with the warrants themselves to Google, Apple, et cetera. And the persons that processed the evidence received, would they have
knowledge of and access to the affidavit?
Absolutely, Your Honor.
Questions and follow-up to that?
Yeah. I do. How would people that are getting an email through a portal, Apple, Google, AT&T, how would they have access to the affidavit?
The question was the people that received the evidence, not the people who sent it. So in other words, the police and team that reviewed the evidence, did they have access to it? Not, that wasn't my question.
Okay, I didn't hear you. You do
Just
have
to clarify.
You do have a soft voice, and I am losing my hearing. But so then based on that, how would those folks get access to the affidavit in support of the search warrant when they're reviewing materials?
Just so I'm understanding you, those folks, meaning the people who work for these companies, is that who you're referring to?
No, I think that's not what the judge was
Right, I
asking.
understand.
He was asking that once that evidence is returned and you log it, his question was, do they have access to the affidavit in support of search warrant?
Right.
And your answer to him was yes, absolutely.
Yeah.
How?
There were paper copies of it. It was no secret. It was shared freely amongst the investigative team.
Okay, but not each person reviewing, various people are reviewing these, the electronic data for the some 67 devices and third-party warrant returns, right?
Yes, ma'am.
And in terms of my question earlier, which was who, I was asking about Apple, who's reviewing that data? Your answer was, I don't know, right?
Yes, ma'am.
So if you don't know who's reviewing something, how would you know that they have access to a search warrant affidavit?
Well, that's the beauty of having a collaborative team effort. If you share the information freely, it's not independent upon myself to provide that to them. Everybody has that information to reference.
So is in the database that you're creating with this collective, I'll stop this, break this down. My understanding is that the collective document is Exhibit A, correct?
Correct.
And then when you attach Exhibit A to a warrant with Exhibit A to a affidavit in support of a search warrant, you also add additional language depending on who that warrant is for, right?
Correct. Yes, ma'am.
So there are over 100 different search warrant affidavits in this case. And it's your testimony that everybody who would have access to doing review of data has access to go in and look at what exact search warrant affidavit was executed?
I believe so, yes.
Okay. I have no further questions.
Follow up from the state on that. All right, thank you, Detective.
Judge, I think we don't need to step away, but I do need a break to organize my documents
Just watching.
for the next witness, who will be Detective Mowry.
I'm speeding it up. Zoom, zoom, zoom.
All right, the defense calls Detective Mowry.
All right, Detective Mowry can come be sworn. When my staff took the opportunity to take a break, they'll be back in a second, so we'll just get them sworn in and we'll wait for them.
Detective Mowry!
Do you solemnly swear affirm the testimony you're about to give now before the court is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And I think it's fine if you just want to start with his, if you're going to ask him his background, you can do that.
Thank you.
Good morning. Detective Mowry, could you please state your name and spell your last for the record?
My name is Lawrence Mowry, Mowery.
What's your current job?
I am a forensic detective with the Moscow Police Department.
And could you tell us about your background in law enforcement?
I have 14 years of law enforcement experience in the state of Idaho. I've been with the Moscow Police Department for the last 6 years in this current role.
What is your role in this case?
I was, put in charge of, lead, I don't know. I was the one that was looking at and funneling the excessive amount of digital data and evidence that was coming through.
Have you taken on any other roles in this case? Have you had other duties?
If you're asking about serving warrants for digital evidence, then I've done that, yes.
And you've heard Judge Mike?
Yeah, you're fine. Go ahead.
Okay. Do you agree that the Exhibit A that's been discussed was and attached to warrants, that was a group effort?
Yes,
Have you been a part of that group?
I was.
What role did you have in the first AT&T warrant?
I don't recall specifically. I was there when it was being discussed.
Do you recall that you served that warrant?
I do.
When you served that warrant, did you serve it with the search warrant, with the affidavit in support of search warrant attached?
No, ma'am.
Is it your practice to ever serve an affidavit in support of search warrant with the warrant?
No, ma'am.
Were you co-located with Special Agent Nicholas Balance as well?
Yes, ma'am.
What was the distance that you had in proximity to him?
He sat in the same lab that I did.
And so was that a cubicle setting? Can you describe the setting?
It's a secured forensic lab. It has a door.
And then
Co-location?
inside, is it open? Were you in separate offices?
It's a single room.
Single room. And so you were literally in the same room with Agent Balance?
Yes, ma'am.
And was that for the entire time that he was co-located there?
Yes, ma'am.
Were you aware of his ability to have access to AT&T records without a warrant?
No, ma'am.
All right, I want to talk now about the cell phone, also known as the USB. Do you recognize that? I should say, I'm so sorry, because there are so many cell phones. Brian Kohberger's cell phone, I want to talk to you
The
about.
physical cell phone or the data from the cell phone?
We're going to talk about both of those. So for purposes of today's argument, we've called it cell phone / USB. How did the state come into possession of Brian's phone?
Obtained via the warrant in Pennsylvania.
Was a copy of that phone made prior to the search warrant being signed?
Which search
Copy
warrant?
of Brian's cell phone.
Again, I'm asking which search warrant you're talking about, the one from Pennsylvania or the one that we requested once the data returned?
I'm talking about when it was first seized, so it'd be the first.
The Pennsylvania one?
Right.
I do not know.
You're aware that a copy of the phone was made and put on a USB,
Yes.
and then a warrant was obtained to search the USB.
Yes, ma'am.
And that's the second warrant.
Yes, ma'am.
Was the cell phone searched prior to the warrant for the USB?
The extraction was created before the warrant in Idaho was requested.
Was the extraction searched before the warrant was obtained in Idaho?
No.
And how do you know that?
I was the one that received the extraction.
The extraction, where was the extraction made?
Pennsylvania.
And who made that extraction?
I believe it was Special Agent Tanzola.
And how did Special Agent Tanzola get that extraction to you?
You'd have to ask him. I believe it was using a Cellbrite product.
So
I wish I could attend like a digital forensic conference where they talk about like Cellbrite and all the newest and latest like technology, for forensic stuff. Like, it'd be so cool. But of course, it's probably reserved for all the professionals. But I just want to be a part of it.
So what about is the USB not a physical box of the extraction, or is it all digital?
USB is just a storage device that the data would be placed onto.
So with the extraction and the USB, can you explain the process of the extraction being made and it getting to you and it getting put on a USB?
Do you think the argument that the defense is trying to make is maybe law enforcement looks through the extraction after getting the warrant in PA? Yes, but before getting the Idaho warrant? You think that's where she's going to?
Normally, in a forensic environment, the device is extracted at extraction and then therefore replaced onto a different storage device for evidence storage or for sharing with other forensic investigators.
And so you said normally, but I'm asking you specifically to Brian Kohberger's cell phone.
Because they're asking about like emails, right? So it's like, oh, well, maybe they got an email and the email they obtained before the Idaho warrant went out. Maybe.
The data was placed on a storage device by S.A. Tanzola and provided to me.
Okay. And how did you get the storage device?
I believe it was brought back. I don't recall how it was given to it. It was still in the FBI packaging.
Do you have any personal knowledge of whether or not Special Agent Tanzola reviewed the data of the extraction before the search warrant in Idaho was obtained?
I don't recall.
Okay.
I don't recall.
Judge, this is one you don't have yet either. This is Defendant's Exhibit A to cell phone. And it does have a sticker on it.
We like stickers. We like labels. We
You have
like
an extra copy of that?
organization.
Pardon?
You have an extra copy of that?
No, once, I handed two, right?
Yeah, just going forward, I need 2 copies.
I will. I heard that message yesterday, Judge, and I apologize. Moving forward, I will make sure that there is that extra. I'm assuming you went up for your clerk. So.
My staff attorney,
Yeah,
yes.
yeah. Okay, that's not great.
Yeah, I'm thinking maybe it has to do with the emails, the email addresses.
And just for the record, as I've been doing, this has been marked Defendant's Exhibit Number A with a date on the sticker of 11/14/24. The document on which the sticker is placed, first page is affidavit for search warrant. Directed to the Moscow Police Department Forensic Lab.
Detective, how did you create the affidavit in support of the cell phone of the USB warrant?
How did I create it?
Yes.
I'm not understanding. That's a vague question.
How did you go about drafting this? Is this a document that you had, that you filled in from, or did you start from scratch? How did you
I
come
don't
up?
remember the exact way that I did it, but it's not. This isn't very different from, say, an ICAC warrant that I would have had previous intentions to search the cyber tip information that would be already placed into evidence at the digital forensic lab.
So when there's knowledge about what you're asking for and lists of things to get, what are you basing that knowledge on?
I would be basing this on information that I've done in previous cases, other warrants that I have served, and other warrants that I have viewed from other investigators throughout my time.
Imagine if our emails were made when we were kids, get read in court. Those emails with the names that we thought that were so cool. You know, luckily for me, when I was a kid, I don't think I ever chose cringe usernames. My cringe username happened in my mid-20s, and it's still used for Facebook, and I still don't know how to fucking change it. I keep trying to update the email, and it just doesn't work. So my Facebook email is cringe as fuck. But yeah, when I was a kid, my emails were like cotton candy, herbal tea, red strawberry. I don't know. It's just like food and drinks and tea. The new Master 69 Slayer. What is the cringe name? I'm not telling you guys. It's so cringe. But it does have a 6'9" in it. 6'9" is in it. I will confirm that. I didn't have an email when I was a kid. It didn't exist. Yeah. My first emails were like Yahoo and AOL. Duh. AOL was first, and then Yahoo, MSN. Mm-hmm. Mevs versus me versus the world. Nerd. Keep in mind, this came before Corgi's side. Listen, I'm just like a very uncreative motherfucker, okay? Because I'm like, I like corgis. Okay, that's it. Yeah, share me your guys' cringe email addresses. Or if you're just like me and you're boring, you're just like, I just put food. When she started housing a needy corgi. Steve was pretty needy. You're right. He was pretty needy. Dude, I woke up today and look at what was in my face. I felt something fuzzy on my face and I was like, oh, is that Shiro? And I woke up and his foot was in my fucking face. So, you know, when you guys see me in a couple of weeks, when I have a bunch of acne on my face again, blame it on Shiro. Okay? Look at this guy. I woke up and this butt was in my face. Hold on, let me see. Can y'all see it? Can y'all see it? His foot right there. All up in my face. It's him right there. Taking over Dennis's spot. I will say though, now that I'm really making sure that I flip my pillow sides, because sometimes my hair gets greasy, and so when it gets greasy, I sleep on one side of the pillow, and then when my hair's clean again, I flip it on the other side. My skin's been a little bit more clear, so I don't know if that's a contribution, or maybe the air is a little bit less dry. I don't know. But damn, I don't know. For some reason, like every time in the fall season, the acne just like explodes on my face. My dog has attachment issues, but don't like cuddles. She will sit on top of people, refuse any infection. Oh my God, that's so funny. It's like, look, but don't touch. It's like, I'll be in the room with you, but I'm going to be at arm's length. Don't touch me. Cheryl's like that too. He'll like specifically stay at arm's length, you know, because like he doesn't want to get pets. He doesn't want to be cuddled or anything, but he wants to be nearby, you know, just in case. Nearby, in case you have any food.
Can you turn to page 24?
Hello. What's up, Michelle? How are you doing today?
You see that page?
Yes, ma'am.
And is that page entitled Search Warrant?
Yes, ma'am.
Looking at the first paragraph of that search warrant, is there any reference to search warrant affidavit in the warrant?
No, ma'am.
And is the date of the crime on the search warrant?
Oh, did your mom get the clear, by the way, Jan? Or does she still have pink
No, ma'am.
eye?
On page 25, can you turn there? There's a directive to search the premises. Do you see that?
Yes, ma'am.
What's the premises listed as?
155 South U in Moscow, Idaho, in the forensic lab. 155 South of U, one word.
You got mail.
Does it say USB in that descriptor?
No, ma'am.
Can you turn to page 28?
I'm going to call the airline and
Is
say that
Key
she has the
Computer
flu.
Forensic Lab?
Key is not a person, it's a thing. It unlocked the secure cubicle that the USB was placed into by myself so that it was secured. I had the key, and entrance was obtained by Key in the Computer Forensic Lab.
Okay. That makes sense now. I thought it was the name of a company, and I don't know why, but that makes sense. Key Computer Forensic Lab. Who was ultimately in charge of searching the USB drive?
The data was extracted, or not extracted, but reviewed by several different people.
Okay, who are those people?
I don't know all of them. Myself looked at some of the information, but not all.
And you said you don't remember all of them, but who else do you remember?
The information was also given to the FBI. The FBI had that information, and they examined it.
And do you know who with the FBI?
No, I do not.
Can you turn to page 27?
Yeah, because I was going to say, Jan, I don't usually see you on my court streams. You must be really trying to get away. Hopefully she gets to go back.
Can you look at page 6?
It's been too long.
Or not page 6, I'm sorry. number 6, line number 6. Do you see that? What does that say?
A copy of the warrant inventory sheet were left with the drive.
And that does not indicate that a copy of the search warrant affidavit was left with the drive. Is that right?
No, ma'am.
Okay, I want to talk now about Amazon.
Sure.
Did you swear to several warrants for Amazon?
I did.
Do you know specifically how many?
I do not recall how many.
How were the warrants served? How did you serve Amazon warrants?
I believe that Special Agent Michael Douglas assisted in service of those.
What training do you have in Amazon accounts and records?
I do not have any training for Amazon specifically.
And I think you answered my next question, but there was a reference in the warrants to a special agent locating an Amazon account. Is that the Special Agent Douglas?
I don't recall who was that, who found that information.
How was an Amazon account located?
I don't know.
In your affidavit, where you've got language that talks about what Amazon holds and how it identifies and the list of items that can be collected, if you don't have any training in doing an Amazon warrant, how did you know that?
I was relying on the experts that have worked with or served warrants to Amazon previously. I believe that information came from Special Agent Michael Douglas.
And in your affidavit, did you indicate that that was based on your knowledge or on someone else's knowledge?
I based it on mine because I spoke to Special Agent Michael Douglas about it, and he was the one that informed me that this was the information that we could request.
And so
Michael
did he
Douglas?
provide you with a kind of a mock-up affidavit to use so that you would know what language to include?
I don't remember if he gave me a mock-up, but obviously he would have helped me with the wording of it.
The wording of the warrants is pretty technical, right? All the list of items that is asked for.
Any electronic service provider usually has their special way of asking for things.
And so since you don't have training in Amazon, you relied on Special Agent Douglas for that?
Yes, ma'am.
How's your sister
Google
doing?
is the next one I want to talk to you about. What's your training about Google?
Is she going nuts too?
Again, I have no specific training to Google. I've served various email or warrants on Google for other means.
Is your experience with Google isolated to this case?
No.
You've done Google warrants before?
Oh, yes.
How did you get the form that you used for the Google warrant in this case?
The Google form, I probably relied on previous warrants that I've served.
Do you know how many warrants you obtained for Google in this case?
It was 3.
Oh, true.
On January 3rd, that January 3rd, 2023, that warrant asked for Brian Christopher, 1994 at Gmail, 2 phone numbers, and an IMEI number. What's an IMEI?
International Mobile Equipment Identifier?
And how did you get that number to put in the January 3rd, 2023 Google warrant?
I do not recall.
Okay. Were you, in preparation for creating these warrants, were you having communications with Google?
Specifically about these warrants?
About being able to get the data via warrants?
I don't recall communicating with them specific to these warrants.
Okay, I'm going to hand you what's Defendant's Exhibit F to the Google Memorandum in Support.
They must think the evidence is pretty bad if instead of fighting it in trial, they just wanted to have it thrown out. Well, I mean, that's like 2 different battles, right? Why fight it in trial if you can just possibly have a chance of having it all thrown out? So the more battles you do, the better. More chances of winning. Ask Brian if he's missing a knife sheath.
You recognize that?
It appears to be an email between myself and a Francis from Google.
Wait, is it confirmed that his Amazon account did have the K-bar knife sheath purchase or no? I don't remember.
So is this how you were communicating with Google via email?
I was communicating with Google for other, I'm not sure if this is the one for this specific warrant, I guess is where I'm getting at. There was question of what Google could provide. We served Google at one point with a warrant. They said it was, they couldn't do it because there'd be too much data. So they were trying to assist us in, well, basically not spending $100,000 of getting them data.
So to be clear, when I'm talking about the communications generally, I'm talking about your communications with Google about all the warrants. So was there email and telephone communications or just email?
I believe I spoke with their legal representation on the phone. I don't remember if there was other conversations.
Do you understand the difference between a personal account and a not personal account on Google?
I do not.
Okay. Well, there's reference to DeSales and DeSales helping from their end. Can you explain that?
I don't recall what that means.
Do you recognize what DeSales is in the course of this case?
It references an email address that was associated with the defendant.
Okay. And that email address associated with the defendant is a college that he attended, right?
Yes.
And so was there communication with DeSales about them not wanting to produce records pursuant to a warrant because it was educational records protected by federal law?
I was part of a little bit of that. Detective Payne knew more about that conversation, but yes.
And so what I'm trying to understand is what was DeSales doing to help?
I believe DeSales was just waiting for a warrant. I don't recall completely.
And did you serve the Google warrants?
I believe I did.
I believe you said you did?
Yes.
And consistent with what you've said earlier, you did not include an affidavit in support of search warrant with that?
Says Kohberger bought a K-bar knife and knife sheet from Amazon 7 months before he allegedly stabbed 4 University of Idaho students. It has been revealed. Where was that revealed? Why are they? Why did they just write "it has been revealed"? Is it during this case? Or appear in court for arraignment. Oh wait, was it in the arrest affidavit? I don't remember.
Why did you choose the time frame of January 1st, 2021 to December 30th, 2022?
I don't recall the specific reason why we went back to January 1. It was to include the time that we believe that the defendant had entered Washington to become a student nearby the crime scene and just prior to that.
Okay. But you know that he didn't come to Pullman, Washington until June of 2022, right?
Correct.
Did you review the Google warrant return emails?
Yes.
Did you review, so you said you reviewed them. Are you the one who's in charge of evaluating those materials for this case, or is that designated to somebody else?
The materials came to myself, at which time it was disseminated to other investigators and the FBI as well.
Is it fair to say that between warrant 1 and warrant...
They're looking through for possible click activity pertaining to knives and accessories for Amazon. So I don't know if it's been confirmed. I just see probing click activities for knives. Amazon warrant reveals search for knives. Maybe they got like the search for knives, but then not an actual purchase, maybe?
3, it's gone from 2 gigs to over 13 gigs of material.
It was substantial information.
And have you done anything to verify whether or not the materials produced are within the scope of the warrants?
I usually made sure that they were from that specific account. When it's received, I did not go into depth of the evaluation.
Let's talk, the final area is about the Apple warrant. What was your role in those warrants? In that warrant, sorry, not plural, singular.
I don't remember that specific one. I know I was involved in a lot of the Apple iCloud warrants.
What kind of communications did you have with Apple to facilitate getting the warrant?
I don't recall prior to.
I'll hand you what's been marked as Defense Exhibit C to the Apple warrant. It does have a sticker on it. And it's not to the Apple warrant, it's to the memorandum in support.
Exhibit C attached to their memorandum dated, exhibit sticker dated 11/14/24. Appears to be a printout of some emails.
Emails. Birdfinger energy.
Have you reviewed those?
Yes, ma'am.
Can you, does that help refresh your recollection regarding what communications were occurring?
It appears that there was communication between Apple and the FBI.
Okay. And were you included in that?
I believe I was.
Okay. And did that include chats,
I believe the word chat means to chat, to talk.
like telephone talk or Zoom talk, or what was the method?
I believe it was telephonic.
So what kind of help were you getting from Apple, and what was the FBI getting from Apple?
I don't recall the conversation. This was more specific to the FBI's current investigation. As I stated in my email there for the stalking investigation, I was merely just privy to their conversation.
Have all of their materials related to that been turned over?
Who's there in that sentence, Counsel?
Pardon?
Who's there in that sentence?
Sorry, FBI.
FBI.
I do not know. I wasn't, I don't know.
I have no further questions.
Judge, any questions?
A few questions, Your Honor. Can I stay here? No. Just a few follow-up questions. When you received the evidence back from these various providers, did you have access to what we refer to as affidavit for search warrant and Exhibit A?
Yes.
Okay. And did you use that to determine the scope of what you would be searching for from those providers?
If I was to be doing the investigation, yes, I would have looked at those items.
And you testified that several investigators helped MPD in review of evidence back from providers.
Yes.
To your knowledge, did those investigators have access to the affidavit and the Exhibit A?
Yes.
I don't have anything further. Thank you.
You redirect.
No, Your Honor.
Thank you.
Thank you, Your Honor.
I have no further witnesses.
All right, why don't we take a 10-minute recess, and we will then pick up.
All right, 10-minute recess. Let's get up and stretch, and then we'll be back. This one's gonna be a lot shorter. Oh, make sure you get up and stretch. Little arms. Little arms. Okay, part 2. This would probably be maybe 40 minutes long. I like how the court audio is nice and loud.
All right, we are back on the record in State v. Kohberger. Defendant is present. Counsel are all present. I'm heard.
Just kidding. I'm going to make it louder.
More witnesses to present by either party. Is that accurate?
Yes.
Yes, Your Honor.
All right, we'll move to argument then. The defense may proceed.
All right, argument time.
Judge, I'm going to cover several of the warrants, and then Mr. Logson's going to cover 4. So I'll just wrap all of my argument up instead of getting up and down for each one. My oral argument is not meant to rehash every point briefed or every argument briefed. I'm giving you big picture comments based on the testimony, but I want to make it clear that we're not waiving any written arguments.
He's
While
sleeping on
I
the
questioned
staircase.
Corporal Payne and Detective Mowry about some exhibits, but not all, it was not an indication that others are not important. I wanted to make important points, but not belabor. With IGG and Franks having been addressed yesterday and the fact that the primary issues that I'm addressing have to do with general warrants, I'm not going to rehash those arguments, and I'm going to focus on the legal issues, beginning with the AT&T Warrant 1, Pen, Trap, and Trace, also known as AT&T 2, and the cell phone/USB drive. The Fourth Amendment requires particularity sufficient to prevent the exercise of discretion by an executing officer. The particularity requirement's objective is that necessary searches should be as limited as possible. A search warrant must be particular enough so that, as to what is taken, nothing is left to the discretion of the officer.
Oh, I think I remember that too. The argument that the defense was making previously was that they said these warrants were very overly generalized and not specific enough. Like, hey, we are seeking X, Y, and Z. It's like, hey, we're seeking all of this. I remember that was the accusation they were making.
Executing the warrant. The government cannot seize the haystack to look for a needle. And there is an undisputed privacy interest in cell phone data, including cellular site data pursuant to Carpenter. All 3 of these warrants were issued in December 23rd and early January 2023. The 2 AT&T warrants were issued on December 23rd, 2022, within an hour of each other. The first did have a temporal narrowing. AT&T 1 had November 12th, 12 a.m. to November 14th, 12 a.m. The warrant itself was extremely broad and did not incorporate the affidavit. In support of this actual failure to incorporate, the officers admitted that they did not incorporate in the search, but to the extent that the state is going to argue that when the warrant says upon offer and proof, that is the same as hereby incorporates an affidavit, I pointed out the language in certain search warrant affidavits to show you that they do know what it means to actually use the language herein is incorporated Exhibit A, and that same language is not used in a single search warrant affidavit. So the incorporation that would be a remedy for this issue potentially of particularity doesn't exist when the search warrant affidavit is not included. Even if for some reason you were to determine that there was English language meaning upon proof, an oath is the same as hereby incorporated, the language in the search warrant affidavits themselves is extremely broad. The affidavit of return signed by Detective Paynes, this is on affidavit AT&T 1, says that the warrant was served by email, and as he indicated, it did not include the search warrant in support. Email.
Hold on. Give me a second. I just want to make sure I have everything that she said correctly.
12 a.m. The warrant itself was extremely broad and did not incorporate the affidavit. In support of this actual failure to incorporate, the officers admitted that they did not incorporate in the search, but to the extent that the state is going to argue that when the warrant says upon offer and proof, that is the same as hereby incorporates an affidavit, I pointed out the language in certain search warrant affidavits to show you that they do know what it means to actually use the language herein is incorporated Exhibit A, and that same language is not used in a single search warrant affidavit. So the incorporation that would be a remedy for this issue potentially of particularity doesn't exist when the search warrant affidavit is not included. Even if for some reason you were to determine that there was English language meaning upon proof, an oath is the same as hereby incorporated, the language in the search warrant affidavits themselves is extremely broad. The affidavit of return signed by Detective Paynes, this is on affidavit AT&T 1, says that the warrant was served by email, and as he indicated, it did not include the search warrant in support. The description of the property in Exhibit A to AT&T described the property as just a phone number with no other description of the property, which indicates a lack of knowledge of what was actually seized and going to be searched. The second AT&T warrant and install pin trace was requested within 1 hour of the first warrant return at 3:50. The data from warrant 1 was analyzed such that by Special Agent Balance, such that Detective Payne was relying on Balance in his affidavit to support it by saying that the data that had been in their hands for less than an hour supported that the phone was possibly off going south on Pullman at 2:42 a.m. And there is just got to be a question for everybody of how does this massive amount of data get analyzed in an hour to create a second, broader warrant?
Okay, I see what she's saying. Fuck, how could I put that in my notes? Data had for 1 hour, then got second with more particularization. Specifically, that the car was going south on Pullman at 2:42 a.m. So she's essentially saying that they already had this knowledge somehow, Because how does someone sift through this ginormous data and then within the hour was able to find this one pinpoint fact that he was going south on Pullman at 2:42 a.m.?
Just got to be a question for everybody of how does this massive amount of data get analyzed in an hour to create a second, broader warrant? The warrant language in AT&T2 pin trap trace is extremely broad, and the time frame goes from June 23rd, 2022 to present. The crime of homicide was stated, but the date of the crime was not stated. There was no other specificity in the actual warrant. The warrant asked for extensive data, location data, timing reports, cell tower information. Warrant. The warrant language in AT&T2 pin trap trace is extremely broad, and the time frame goes from June 23rd, 2022 to present. The crime of homicide was stated, but the date of the crime was not stated. There was no other specificity in the actual warrant. The warrant asked for extensive data, location data, timing reports, cell tower information, and installation of a pin, trap, and trace, among other many things. And when the warrant was served, a check the box form was included as a cover sheet to AT&T. Turning to the cell phone is first seized when Brian is arrested. It's copied by Special Agent Tanzola without a warrant, and then that USB drive makes its way to Idaho in an unclear fashion. It sounds to me like it came back with Corporal Payne, who was there for the arrest. And when that warrant is obtained for that USB drive, it's put in a safe with just a copy of the warrant that has no date of the crime, and there's nothing particularized about what is to be searched. This creates a general warrant with 100% total discretion and nothing to limit the search. And if you believe that access within a database by somebody unidentified other than Mallory, who's going to evaluate that warrant, that they're going to look and pull that finalized search warrant from the database that everybody supposedly has access to, looking at that search warrant affidavit, there's full discretion to search the USB drive. There's no limitations and no efforts taken to address that. Turning now to Google and Apple. A very instructive case on Google and Apple is the Idaho pilling case, which is 721 FSUP 3D 1113 2024. It's almost totally on point with this case. It is a federal case out of the District of Idaho beyond the 11 pilling case,
Idaho pilling
which is
case.
separate in terms of looking at these issues with Google and Apple. There's without a doubt a recognized protected interest of private information in Google and Apple records. Google contained private emails, schoolwork, research among things, and Apple was essentially a copy of a phone and iPad that went all the way back to 2016. 2018 was an indication of when an iPad was purchased, but 2016, according to the documents that were prepared, were when it was identified that an Apple account was first created. Carpenter applies, and to the extent that there may be third-party materials like search history not related or documented, nothing was done to do any sort of segregation with regard to Apple or Google. For the Google warrant, by January 3rd, 2023, law enforcement knew many details that they could have used to narrow those warrants. They knew that Brian hadn't been in Pullman until June of 2022. They knew the names of the deceased, which were not included as language in the Google warrant. They knew the fraternities and sororities. They knew the students' names who had also been at the house on the morning of November 13th, 2022. They knew the date of the crime, of course. They knew emails. They knew social media accounts and names. They knew where students worked. They knew their friends. They knew their phone numbers. None of that was included in the Google warrant to help limit and make that something other than a general warrant. There's no language incorporating these search warrant affidavits, making these broad, sweeping categories, making the productions bigger and bigger. In Google, it went from 2 gigabytes to 13 gigabytes by the third production. And it appears that it's really unclear to these detectives that have taken a huge role in this case, who's evaluating what data and to what.
Brian, thank you so much. Oh my God, it's like a bright pink boom. Corky, thanks so much for making this great for all of us. Brian, thank you so much for your support. I appreciate it. Thank you. That's huge. Thank you. I really appreciate that. So they want the court to determine the warrants were unacceptably broad. Once they have the data, someone may have searched a specific time window. So she's saying that, well, one, it was way too broad. It needed to be way more specific. But but does that go back to law enforcement, or does it go back to the judge that granted the search warrant? Like, how does that work, right? That's one. And then the other issues were, possibly them already knowing information by legally obtaining it and then putting it into the new search warrants. Did that happen? I don't know.
What extent and what is being produced by it and what is within the scope of what is in an already broad warrant. For Apple, we are missing a sort of legal process that the state just hasn't filled the gap on, and these witnesses don't fill the gap on. We don't know what the legal process is that is referenced between the first request.
Hold on a second. I got to go downstairs real quick. Oh. Okay, where were we? And again, Brian, thank you so much. I appreciate it. Should I drink my protein shake? We're about halfway there.
Request for a preservation in December 21st, all the way until August, when there is a production on a warrant. The steps that have been taken in between to get the information to put into the warrant are completely unclear, and to the extent that these officers who swore to the contents of affidavits now have no memory of what that is, that's invalidating of those warrants. As for the arrest and the car and the apartment, what I will close by saying on those, because it's not an issue of general warrant or a discussion of particular.
Yesterday's hearing as well, you would know that law enforcement purposely misled the magistrate by not including certain information, using information out of context, or not including information. That part, that's where I started getting a little bit lost, because she did mention that there was like video surveillance of the car, and that the video surveillance showed the white car, but then you couldn't tell that there was like, you couldn't identify what vehicle it was really. But then there was like other surveillance footage that would have showed the car going like one direction and then like the other direction. I don't know, honestly, like when Ann Taylor was describing it, I did get a little bit lost in that part, but I do remember her making that argument.
Particularity, those are more reliant on the issues associated with IGG and Franks. And with that, I'd ask that you find that the warrants that I've just discussed are general warrants, not particular warrants, and they should be suppressed.
All right, straight to the point.
Do you want to respond to that, or do you want to have the defense argue the additional warrant issues and then address them all?
I'll take your lead, but I'm happy to just piecemeal this, and I can address just those. I can make this pretty simple for the court. We don't have to go down the rabbit trail that the defendant would like you to go down. The search warrants regarding the particularity requirement. And this group that we're talking about is Apple, AT&T, there was a first and a second, Kohberger's phone, and then Google. All of these warrants were not general warrants. They were all sufficiently particular. They were specific to the type, each one of them listed that they were specific to the type of crime, the location, and all but one of them had temporal limitations. And for the one that didn't, that would be the cell phone warrant. That warrant was more particularized in the types of data that officers were allowed to search for. It's the state's positions, these were not general warrants, and your court can determine that just by looking at the face of the warrant. If you have any questions, otherwise, state submits, you should deny their motions to suppress for these issues.
Holy shit, that is a super short argument. Okay. Is there a copy of the warrants on the court's website? Do we have a copy of it? I don't, oh God, there's a lot on here. I don't know. Maybe it's like attached. Or maybe it's sealed. Probably sealed, right? Okay, that was a short argument. She said they were all very specific to the crime, the location. One of them was temporal. That was in regards to the cell phone. And these are not general warrants. They do not lack particularization. That's all I've got to say. Boom. That's it. Okay.
Your Honor, I was
Who this guy?
asked to argue the motion
Defense?
regarding the raid on my client's parents' home,
Okay.
the search of his person here in Idaho, as well as in Pennsylvania, as well as and the Amazon warrant. I think for the most part, I'll just rely on the briefing. I just want to clear up a couple of things. One of the areas that was covered in the Pennsylvania home raid was that the state had to have a valid warrant in order to enter the home. I think in the briefing it gets a little confusing, but the point was not that Mr. Kohberger couldn't have been arrested as he was walking down the street via the usual channels in which that could have occurred. The point was that they had to have a valid warrant in order to get into the home. The only warrant that they have is the one that we're challenging and via the Franks motion. And so that was the purpose of that argument.
Oh, wait, hold on a second. Did they have a Idaho warrant, But then, fuck, what was it again? I could have sworn the defense was trying to say that they should have had a Pennsylvania warrant, but instead they had an Idaho warrant, and they used that to get into Kohberger's house. I don't know if I remember incorrectly, but I could have sworn I remember hearing that being one of their arguments. Like they didn't even have the right state search warrant.
The other issue in terms of choice of law, it sounds like the state's kind of accepting that Idaho Constitution should apply
To Pennsylvania?
We set out a few different reasons why that should be the case, but it doesn't seem like there's a big argument going on there. So unless the court has questions about it, I'll leave that alone. And then the other issue that I wanted to touch on is the right of privacy in the information that we have in our Amazon goings about. Why should the state have to have a warrant for that? I thought we set it out pretty well in the briefing, but I think, the big concept and takeaway here is in Carpenter and Riley, the United States Supreme Court starts doing something different. And I think what the court is starting to recognize is that to a great extent, the United States has become a sort of panopticon. That is, the concept of the panopticon is you have a prison in which you only need a small number of guards because you have a very heavy-duty surveillance system. In the United States, we have via our phones, via the internet, much of what we do is now surveilled and very easily accessible. Mm-hmm. And so the fact that we have the third-party doctrine made sense when it was being adopted back in the...
Did you say doctrine? Oh, gosh. What was the... I need a refresher. I know Carpenter is a cell phone one. What's the Riley case? Riley. Oh, the one that had their car impounded. They searched their phone and they found a Crip killer, and then they tied the person to another crime, like a murder or something. Okay.
The 70s,
What year
the
was that?
60s. It stops making sense once all of this information is easily accessible in the way that it is.
2014.
And so our point is that the judiciary has to have a role in this. There has to be a judge between us and the executive. Otherwise,
Hey, Steph, how is selling stuff by the seashore? Any success there? Are you Lamborghini rich yet?
we're essentially allowing the executive to know everything about us all the time. And so the state makes the point that, similar to the one that Professor Kerr made about going and getting bank materials, once those were things that could be done simply and efficiently via these records, a person didn't have to go out and get the cash. The state argues in this case.
Professor Kerr, I don't remember hearing that name. Is that the professor, Harvard professor? Professor Kerr, legal scholar. Oh, Berkeley? Is it Berkeley? Stanford? Oh, God, there's so many people. Maybe it's Stanford. What would I search? Privacy interests? Privacy interests, maybe? Digital Fourth Amendment. Professor Kerr. I think I found him. Oh, Berkeley. I think that's him. Okay, I'll look it up later.
Because of Amazon, Mr. Kohberger didn't have to go someplace to purchase items. All of that would have been out in public, but he's doing it on his computer, and so why should that make it private? And the reason why that has to become private, Your Honor, is because of the vast amount of information that is now so easily accessible to the government. If we don't require a warrant, we essentially put all of ourselves at hazard of being snooped on at any time. And so I also just want to just briefly bring up, I think yesterday the court had talked about privacy rights with the IgG databases, and I certainly want to make sure that we are preserving that argument. We included it in the briefing. We do believe that Americans have a privacy interest in the genetics that they share with other people and that other people then place within these databases. So that is not something that we intended to abandon in any way yesterday. If the court has no other questions for me, I would rely on the briefing.
Thank you.
Thank you.
Sorry, completely unrelated. So you guys know how I don't know if you guys saw my Instagram and then my rant on Discord. I couldn't find any eggs because eggs are really hard to get right now. So I got these carton of vegan eggs, and oh my god, they're a fucking nightmare to cook with. It's like cook with a non-stick pan. That's what I did. Dude, it sticks on the fucking pan so much. How do you cook these goddamn vegan eggs without it sticking on the pan? It's like a nightmare to clean. Sorry, if anyone knows, let me know. I need help. I have issues. I just want to eat some damn eggs. It tastes pretty good, though.
I'd like to address just the third-party doctrine, and then I'd like to turn it over to Mr. Thompson to address the other motions.
What's a vegan egg? I don't fucking know. I have no idea what it's made out of. It's a carton of vegan egg, and it actually tastes pretty good. But the issue that I'm having is I can't fucking cook it. It just sticks on my pan. It's horrible. How's everyone doing? Hot. It's getting hot in here. How are you doing?
To suppress. And the case that we're talking about is the Amazon records, and that's what has to do with the third-party doctrine. And the U.S. Supreme Court case State v. Miller is the controlling case here. And Idaho courts, as explored in my briefing, apply Miller. And there's no reason for this court to diverge from that Fourth Amendment analysis. The documents are Amazon's business records.
I don't know if I like this argument. Oh, Jesus. Amazon are just business records, y'all. That's why, law enforcement can obtain it without having a warrant. They're just business records. So Fourth Amendment, again, is like the unlawful search and seizures. But the third-party doctrine is an exception to the Fourth Amendment. Third-party doctrine says that, for example, she's citing Miller. Miller's is it the cell phone records, I think? I get it all mixed up. There's one with cell phone records, I think, where the law enforcement was able to get the records, and the justification for that was, these are third-party records. And so when you're doing business with them, you're assuming that because you're sharing information with them, that they're going to be able to share that information with others as well. I don't know. Sorry, that was a really jacked up explanation of it. But I mean, I think it sounds just as bad as what it is, though. It's like, these are third-party records, so you can't have an expectation of privacy here. And then she's extending that to Amazon. And I'm like, to Amazon, though? But Amazon is not just, what phone numbers I'm dialing. Amazon is like everything now. You're like shopping your groceries, maybe even have your prescription filled. And there's Amazon Echo. I don't know. That's a lot of fucking information. There's your search history of what you're buying, what you're thinking of buying, what the movies you're watching. Ugh. I mean, I'm all for let's catch the fucking bad guy, but I don't know. It's just it's weird territory. It's weird territory for me. This attorney seems so AI. Fight me. She's super chill. I don't know. She's just coming in, hands in her pocket. All right, so y'all, they're arguing that it lacks particularization, and I'm saying it don't lack particularization. Boom, that's it. All right, I'm done. She got like that chill energy vibes, dude. Like super chill energy vibes. Like she just in here strolling in. Like when she was arguing yesterday too, she was like very super chill. What bidet? Leave the bidets alone. I know. I mean, my bidet is a smart bidet. You could technically probably link up to Toto and then figure out what my bidet usage is. I've never cooked with them, but do you have silicone that you can use in a microwave that might work? Do I have silicone that I can use in a microwave? No, I have maybe glass, but I'm just trying to scramble the eggs, or I guess you could just omelet it, right? Cook everything else first with a little bit of oil and add the eggs last. I'm so lazy when I cook breakfast. I don't add anything to it. It was just eggs. I put a little bit of oil. Initially I thought maybe the heat was too high, so I turned the heat down today. I turned the heat down and put the oil in, and then I put the eggs in, and then it just sticks. It just sticks. I don't know. It just sticks. It's annoying. So maybe I have to. I don't know. But if anyone has any other ideas, let me know. The privacy issue needs to be resolved with the way everything is now. Yeah, because it's like Apple. I was talking about this earlier with Apple. Apple also has a lot of information on you. Try steaming the eggs. Hear me out. Steaming the eggs. Oh, you mean like microwave? Oh, I could do like Korean style where you put it into a glass bowl, add a little bit of like dashi or soy sauce, and then like microwave it maybe? Like that way? I guess I could try that. I wouldn't say chill spacey. I don't know if I get spacey vibes. I just get like chill vibes, like Omega chill vibes. You got her. AM, mushroom, therapy, the Korean style. Okay, you know what? I think I'll try that. That sounds like a good idea. I'm just tired of scraping my stupid pan.
The documents are Amazon's business records. They detail transaction history. Business records are most akin to bank records, which is allowed. Applying the court's reasoning from Miller, again, these documents are business records of Amazon. They're not the defendant's private papers. Amazon is a party to those transactions.
Okay, but I guess like what if, okay, so I said that Amazon can also have other information on you. What if you only limit it to your Amazon purchases? What you're buying, what you're, getting like subscriptions of? What if you only limit it to that? And not all the other information? I don't know, man. That's still, I mean, even with the phone numbers, I think that's still kind of like, I would expect that to be my private information.
They have a substantial stake in these records. And the defendant took the risk when he revealed his affairs that this information would be conveyed by Amazon to third parties, including the government.
That's what I've been doing, soaking the pan and washing it later. Yep. That's what I've been doing.
It's the state's position, and it should be the position of this court. The defendant does not have a Fourth Amendment privacy interest in Amazon's business records. Thank you, Your Honor.
Okay, so when I was listening to her yesterday, I think we had her sped up at like 1.5 or 1.8. I didn't realize how ultra chill she sounds at listening at normal speed. Okay, well, that's my position, and that should be your position. Okay, Your Honor? All right, that's it. Yeah, I'm done. All right, thank you. I wish I knew your name. I'll try to get names. I should know his name because I think he's been on the case from the very beginning. I'm not sure if she's been on the case since the beginning. But I do recognize that beard of his.
Good morning, Judge.
You're burned out on a breakfast idea, so that's why I made an orange loaf. What's an orange loaf? My breakfast is I do the bone broth because I love soup, and I'm too lazy to make soup. I have this yogurt that's it's like milk yogurt, but they take out the lactose in it because my life sucks and I don't have any lactase. I do like one soft boiled egg, or in this case, try to do scrambled egg. I have the Dave's prison bread. Fuck, I forgot what it's called. I always call it prison bread, but it's not prison bread. It's Dave's killer bread. Dave's killer bread with a little bit of this like nutso peanut butter that I have, which I'm starting to hate the brand because they keep changing it up on me. And then sometimes natto. I don't know. I don't think you guys will like natto though. Natto is like this like Japanese stinky fermented soybean thing. It's really good though. I like it. And what else did I eat? I don't know. Those are usually my main ones. And sometimes I'll have a cereal, but I don't know. I haven't been in the mood for cereal lately. Yeah, Dave's bread is so good. But here's the thing. Bread, mold grows so fast on it that I have to put it in the refrigerator. And honestly, refrigerated Dave's bread is just not the same as unrefrigerated Dave's bread. Unrefrigerated Dave's bread is so like gluttonously and gluey and so good. Then when you put it in the oven, when you put it in the refrigerator, because it lasts longer, it's like not as good. The lemon loaf slice from Starbucks. Wait, that's like dessert. That's not a breakfast. So a lot of people share their Prime accounts with other people. I think they should come to the play as well. Yeah, I share my Prime account with other people. Jennings has been there since beginning. Oh, really? Oh, I didn't know that. Jennings has been there since the beginning. She was with Bill Thompson when he visited the crime scene in November 2022. Oh, I didn't recognize her. I guess maybe I only recognize him, and then I feel like I've never seen her before. But maybe you're right. I'm probably wrong then. I freeze bread. I do that too. But sometimes, I don't know. It's because I don't have a toaster. I have an air fryer. So air frying bread is not the same as like putting it in like a toaster. Yeah, it just doesn't taste as good, but you know, it lasts longer because I was so tired of buying Dave's bread. It's like what, $6 for the bread, and then if you're lucky, it's $6. Sometimes it's like $8, I think. And then what would happen is after like 3 to 4 days, like mold would just grow. And it was like such a waste. So I have to. Why don't you have a toaster? It's a waste of space. I barely use a toaster. I only use it for bread. I don't know. It's just a waste of space. So I just use my air fryer. I would love to have a toaster though. I just don't have enough counter space for it. I can't have one device dedicated to just one food item. Okay. But yeah, one day I would love to have a toaster.
I'm going to address, I guess, the remaining warrants or the questions raised by the defense about the remaining warrants. I'd like to start first with the warrants for the residents in Pennsylvania. That expands into Mr. Kohberger's person under the Pennsylvania search warrants for his person, for his car, which was in Pennsylvania, and then the defense also raises questions about statements made by Mr. Kohberger to law enforcement.
So to be clear, this is Bill Thompson? And the other one was Jennings?
First, as to 119 Lambston itself, one of the first things the defendant offers to the court is claims that there was no local warrant, valid local warrant, and that simply isn't true. As the record clearly demonstrates, there were 3 valid local warrants, Pennsylvania warrants, for the residence, for the defendant's person, and for his car. The defendant then...
Yeah, that was my understanding, too, that there was no local warrant, that they used Idaho warrant, and then later on got the local warrant. But I don't know, maybe the defense was misrepresenting it?
Asserts, and I appreciate Mr. Logston's clarifications, but essentially the defendant asserts that there needs to be a separate special warrant in order for Pennsylvania to take the defendant into custody as a fugitive from Idaho on our charges. As we cited in our briefing on this, the statutes in Pennsylvania and Idaho are virtually the same, and they clearly contemplate that a felony fugitive can be taken into custody without a fugitive warrant under the circumstances that exist in this particular case. Now, if the issue is the law enforcement presence or access to the defendant inside his parents' residence, we would submit that's already addressed because the Pennsylvania State Police had a valid search warrant for the premises, for the defendant's person, and for his car. So they had lawful process to be where they were, where they found the defendant and took him into custody as a fugitive. The knock and announce, there was discussion earlier today and the explanation of what happened with the dynamics of the knock and announce. That's detailed in Sergeant Lang's statement, which now has a current cover affidavit to it filed with the court. That's S5. I'm not going to publicly go through all the factors unless the court wishes me to because they are quite incriminating as far as the applicable factors that would justify either an abbreviated knock and announce or, frankly, elimination of knock and announce entirely. And from what we have before the court now,
put the bread in the oven like a cookie pan, put it on broil close to the coil conductor with toasted bread. Yeah, I mean, I use my air fryer to toast the bread. The thing is that maybe I'm a heathen, but I don't like toast bread. I like gooey, untoasted bread, and untoasted Dave's bread is just so good. It's just so good. When you toast it, I don't know. I don't like toast bread. I like just bread out of the bag.
It's clear that the Pennsylvania police were operating in a dynamic sense, reacting to real-time information that was coming in. That's all documented in the various reports and log sheets that have been submitted with our pleadings, which are not particularly lengthy in nature.
Knock and announce warrants are not legal in PA. Knock and announce warrants are not legal in PA. So what does that mean? Can you clarify a little bit more? So if it's not legal, then you can just bust in the house? That's the way that they prefer people to do it? Or you like your bread burnt? Ew.
Sure.
Nasty ass.
Finally, as to the defendant's statements, I think the key notion here on any statements the defendant made, and frankly, he really didn't make much in the way of incriminating statements, is there was never any interrogation. He was Mirandized eventually, but even the prior conversations that occurred with Pennsylvania law enforcement, there was never interrogation. And so Miranda is not implicated, and so there's no issue on the statements themselves. As to his car and his person, as I've already mentioned, there were valid specific Pennsylvania search warrants for each of those. So those are presumed to be lawful. There's been no substantive attack on those. There is a motion to suppress regarding, and I'll use the air quotes, arrest warrant. And frankly, I have yet to be able to figure out what arrest warrant is being referred to. But again, all the actions in Pennsylvania were taken pursuant to valid warrants, search warrants from the Pennsylvania courts and the applicable fugitive.
Okay, that's what I was figuring. Maybe that's what you meant. No knock warrants. Okay, so you have to knock and announce yourself. Gotcha.
Arrest statutes. And so we don't see that there's any issue before the court there. The defense also raised the issue of a search warrant for the defendant's person in a separate motion, which appears to be the search warrant for the defendant's person here in Idaho when he was returned to Idaho. And as the search warrant and the affidavit for the search warrant show, which were attached to our reply, there was a valid search warrant for that. I think any issues to be argued beyond that relate to the ITG and Franks that are already pending with the court. As far as the defendant's, the search of the defendant's apartment in Washington, for whatever reason, the defendant did not include all the documentation with their particular motion to suppress, but we provided that in our response, that there was a Washington search warrant. There was also an amendment to the Washington search warrant. The Washington search warrants, the applications, included all the information, the Exhibit A information from the state, and then the WSU Police Department added their additional state of Washington specific information. There's nothing that questions the validity of that warrant on its face. So, Your Honor, unless the court has questions, I don't have anything further to offer in the way of argument, oral argument.
Thank you. Thank you, sir. Boggs, any rebuttal?
Your Honor, I think I just rely again on the briefing for the most part. In terms of the knock and announce, I think the totality of the circumstances of this particular raid are something that the court has to be cognizant of. I mean, if Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were
Telling me facts about which I have no idea, and so it's not going to be helpful to compare it to
well,
whoever Mr. Roof is. So,
I guess the point is that in this particular case, the state manufactured the exigencies, if they had them at all. The reality is, as they explained in their own affidavit, they're essentially watching Mr. Kohberger as he moves around his house via snipers. I mean, they were quite safe, and there was simply no reason to bash the doors in momentarily after yelling from their Bearcat.
there's two issues. There's officer safety. There's also destruction of evidence concerns.
In the cases that we cited, Judge, when the claim has been that there's evidence being destroyed, the evidence, what's known to the officers is something along the lines of, they hear somebody running away after they announce themselves. It's not typical that the police simply don't knock and announce at all in those cases. They usually give the person the opportunity to surrender, but it's not a particularly long one. And in this case, they don't do that at all. And the only thing they knew is that he's walking around from room to room and that he has some kitchen gloves on. And I don't think that equates necessarily to the destruction of,
Well, that's not all they knew, but I won't go into the detail in order to preserve so as that we don't go into those issues.
Thank you, Judge.
To clarify further, no knock warrants. Sorry. To clarify further, no knock warrants are allowed in PA, but law enforcement must justify the reason. But like, I wonder if they were to justify the reason, could it just be like what the judge said, officer safety and then evidence preservation? Did they have to go in like details like into why it's justified, or can they be very broad about it in Pennsylvania?
But beyond that, we'll rely on the briefing. Thank you.
I don't know. Per whoever talked about it earlier, they said they announced it from the Badger cat. What's it called again? The cat something that we were looking up earlier. They announced it from the Badger cat, and then they bashed the door down. So I'm like, does a Badger cat have like a microphone attached to it or something? I'm sorry, it's not a bear cat. I'm sorry, it looks like a badger. The bear cat. Didn't they say that they announced it from the bear cat? So I was like, was there like a microphone or like a PA system or some sort where they just like shout out loud or something? Damn bear cats.
Okay. Take the motions to suppress under advisement and issue ruling forthwith. The next issue is the state's motion to compel regarding the defendant's expert disclosures.
I'm sorry, Your Honor, the defendant's motion to compel the
Did
state's.
I say the state's motion to compel? The defendant's motion to compel regarding the state's expert disclosures.
We did file ours yesterday, so their motion may be coming.
Well, I would be impressed if they had filed something already on that, given they were just served yesterday afternoon, so.
They were. Thank you. Your Honor, we are here on our motion to compel, asking that the court remedy what the state has done with their expert disclosures. We rely on Idaho Criminal Rule 16 and the court's order setting out what we should do and when we should do it in this case.
Let me ask a question from a
The honey badger.
framework standpoint. I don't know what these folks are going to testify to at trial, specifically as it relates to what they've disclosed. The way expert disclosure issues usually works, I don't tell a party what you have to specifically disclose about your experts. You disclose about what you think you need to disclose. If you haven't disclosed it consistent with the rule and you try to offer it, there's a good chance it may not come into evidence. That's the general framework, so I'm a little, when you try to offer it, there's a good chance it may not come into evidence. That's the general framework, so I'm a little, I guess, concerned about what appears to be you asking me to tell them what to say in their disclosures.
The court brings up a really, really good point, and I think it's a remedy the court has and one that we would hope and ask the court to issue in this case. I think when we filed the motion, Your Honor, we had a couple of disclosures that could appear to be disclosures with wiggle words in them.
Yeah, wiggle words are not going to save the lack of disclosure. I'll let the state know that right now. The fact that you say, well, he could talk about anything else, doesn't mean he's going to get to talk about anything else.
In an abundance of caution, we were worried about those words. I appreciate what the court's saying, and I'm going to make this really short. The lists are problematic for us. There are 4 or 5 experts with lists. I understand what the court said. I like what the
They
court said.
also have reports that they reference.
The lab people do have reports. I understand those are their opinions. When we're talking about, and I'm going to specifically talk to you about their disclosure number 7, it's an FBI agent, Douglas. There's a list of financial records that he collected and looked at. Other than that those records exist, there's not a report telling me what they mean to him at all. If he's limited to say, I collected these records, this is what we have.
My understanding, the state can correct me, is what I understand from the briefing is respect to that, and I think that's the Amazon documents, correct?
Those were some of those documents, Your Honor. There are a lot of others.
Was his expertise was in extracting or reviewing the information and how those were sort of obtained electronically and then simply guiding through, well, this is a transaction on this date that does this, which is not necessarily expert testimony, it's simply testimony.
No, but I believe it's a different expert that they have to do that does not have a report.
But is that expert testimony? Let's just say Mr. Kohberger on X date purchased a television, if for some reason that were to be important, and that this
Was it a $5,000 television, Judge?
transaction demonstrates that this is Mr. Kohberger's account, this is Mr. Kohberger's credit card, and this is the purchase on Amazon. And that was delivered to this address associated with Mr. Kohberger.
Those are factual issues, Your Honor. It's when we get to what do they mean, or I put these things together and I've made this picture out of something. That when we get to opinion. I appreciate what the court's saying. It sounds to me like lists don't do it if you want to interpret a record. That's what we hope to hear. That's what I wanted to accomplish today.
Well, I think it's pretty clear. You cannot simply say an expert's going to talk about topic A, topic B, topic C, and then be able to give a host of opinions that fall within those topics. The requirement is to list what their opinions are and what they relied on to give those opinions. It's different than the civil rule. I don't think they have to give as much detail as the civil rule requires, but they have to at least give what the opinions are and I believe what they reviewed, as I recall the rule off the top of my head.
I believe the court's about right. There may be another term or two in the rule that's specific, but I hear the court loud and clear. I'll point out one last thing and stop because I think I understand how the court interprets these issues and these rules. When you look at page 9 of the the state's objection to our motion. And in the second to last paragraph, they tell you that they will continue to supplement their expert responses based on later discovery or whatever they decide to use. That whatever they decide to use has me worried. So I wanted to bring that up. I appreciate the court saying the court's going to apply the court rules and the discovery rules and follow the case law, and that's all we want. Thank you.
And so that I'm clear, as the state's approaching to talk about this, in terms of supplementation, it's allowed. It needs to be seasonable, which means it has to be not just whole cloth new experts, for example, without good cause showing me why that's necessary. It needs to be seasonable in the sense of the timing of it based upon when the information was received, when it was determined it was necessary to supplement. And then obviously we'll look at that in relation to what may prejudice the other side in terms of the timing of it.
Certainly. I understand that. Their discovery deadline has come and gone. If something brand new happens, that would be a different issue. I assume we would deal with that then. It's when I read whatever we decide to use, that's very, very broad. That's it. Thank you.
I can keep this pretty short. I don't think that there's really much in dispute at this point. State's position, we've complied through our expert disclosures with Criminal Rule 16b7, as well as your court's scheduling order. State understands the framework that you've outlined. We were under the same impression, and I don't think that there's anything else in dispute.
Yeah, so let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert. And the lawyer submits these disclosures. And I think it's really important that you be on the same page if you don't have a specific written report from the expert about what it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over-disclose those opinions in caution rather than under-disclose. Because two things. One, you may find yourself in a bad position if you're not allowed to go into an opinion you felt you were going to be allowed to go to because it's not disclosed. And two, I don't want to spend half our day at trial with me saying, where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is. And so the more exhaustive your disclosures, the less likely it is it's going to draw that objection, and the less time that we're going to waste at trial trying to find where you disclose that. And so I think sometimes, and I'm not saying you did that in this case, I think sometimes lawyers view this expert disclosure requirement as sort of tedious work that they need to get done in order to comply with a timeline, a requirement of the court, and then they sort of move on from it and forget about it. That's a dangerous tact to take. It is, for the case, one of the most important things that you can do is to understand what the person is going to testify to and give a disclosure of what they're going to testify to, what those opinions are, and to be looking at that as you're thinking about their testimony as you should.
It's basically like, let me give you a heads up so when we have the trial, you don't waste my fucking time and the jury's time and everyone else's time.
Be doing certainly now.
I would appreciate a heads up. I like that. I would like that. Yeah, I think a heads up is fine.
It's months away from trial on a continuing basis.
Months away from trial. I don't know what's going to happen.
So I would really stress the importance of that in a case, particularly of this import. And so don't feel like your job is done at this point, because I would suggest to you it's not. That you may consider needing to do some cleaning up and making sure things are more fulsome in the scope of those disclosures and what you're doing. The other thing, I think you tried to do to a degree is you thought, well, we think this is fact testimony, but, in an abundance of caution, we're going to put it in an expert disclosure. Well, if you're going to put it in an expert disclosure because in an abundance of caution it could be viewed that way, I suggest you treat it that way in terms of what you give. Okay? Thank you. And that goes to both sides. I haven't read your disclosures yet, so I don't know, where that stands, but certainly goes to both sides. And I know that also, the rules are different as to what the defense has to disclose necessarily and what the state does to some degree, and so I appreciate that.
Well, I think the court will anticipate that there's a rather large filing that contain a lot of actual reports. Your Honor, listening to the court's comments and understanding where we were a moment ago when we spoke, I feel like I must go through what their disclosures were because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts would
Well,
say.
and if they supplement, you certainly can supplement based upon what they supplemented, and I will permit that, and that's kind of the nature of the beast.
I do appreciate that. And should that become necessary, we'll definitely take you up on that, Your Honor. I want to make a record about some of their expert disclosures, though. All of the lab people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. Other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Ms. Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said is a rebuttal witness?
They said she might be a rebuttal witness, so I suppose now they know what our witness is going to say. I want to talk about the CAST report. The court's heard a lot about the CAST report. When I say CAST report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony. This is what it's going to be. Without much more, it's a picture, and it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those if the court hasn't seen that. Their disclosure number, that's Mr. Cox. That's a person that has not written a report at all. We have no idea besides the state's disclosure what that person's going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated. We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60-some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mowry, Tanzola, and Uri.
Yeah, I'm always surprised when judges have such good memory. Oh my goodness. Like Judge Kranick, for example, amazing memory. I'm like, how do you remember all this?
They have lists of devices or social media accounts that they're going to talk about. That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, me wondering if this particular thing was ever disclosed. So I definitely needed to make a record of that. Further, with the lab personnel, there's a caveat that says they'll talk about other people's reports and other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's brought against us. Brian has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us of what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, but exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out while we make sure that we have a clean record. We appreciate what the court said today, and we'd ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far. That's it.
So I'm going to give both sides an example of what I expect so that you understand. There's been talk in this case about DNA. If somebody's going to talk about DNA and your intent is they're going to let the jury understand what DNA is and essentially going to do a mini course on DNA, I expect to see that in the expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they are conveying that is expert in nature. And so it really does behoove both sides to spend the time to do that. And that's the last I'll say about that. It is probably the most critical thing that you have to do at this point prior to trial, is to ensure that you have not just disclosed, but potentially over-disclosed those opinions and what is required by the rule.
But see, I wonder if like both sides tend to not really want to over-disclose, right? I could see the benefit for the judge because, you know, he wants his courtroom to be running smoothly. But for either side, it's like, man, do you really want to over-disclose? Like,
All right, is there anything else with respect to those?
Your Honor, is the court giving the state a new date to fix their disclosures?
I'm not giving either side a new date. You understand, I think, what I expect.
but she wants the judge to compel the state to do the disclosures. And he's like, well, I'm just going to say this. This is what I expect. She's like, well, I want you to make them, judge.
You can choose to try to supplement those. If they are simply expansions of what it is that they've disclosed that are just being more fulsome, I'm probably not going to have a problem with that, given where we're at in advance of trial. And the defense certainly can look at those and decide that they want to expand or change or whatever their opinions are based on that. If it's whole new stuff, then you're going to have to demonstrate to me, new opinions, new lines, or even new experts. You're going to have to demonstrate why you didn't get that in the timeline.
Thank you.
Okay, is there anything else that we need to take up today?
Nothing from the defense.
Oh, yeah. Whether or not death penalty is on the table, that's still pending, right? Because I remember they're making arguments about that. Right? Was it for this case? Gosh, I get all my cases mixed up. I think it was for this case.
I don't know.
I think they're moving forward with it, but I remember they're arguing about it. Is it still pending?
Whether we're going to have a Frank's hearing or not, I need to go and do that. But if you don't mind emailing some dates that you have available in the next, say, 3 weeks to do that in the event that we need to do it, I would appreciate that. Okay?
I think that's it for today.
All right. Well, I appreciate everybody's work, not just for the hearings this week, but in this case in general. And I know how busy you all are, and I hopefully have not taken more of your time than is necessary. Travel safe. Thank you.
All right, please.
Well, I think, the defense was saying that the state didn't provide any disclosures. That's where I was confused. She said that, like, oh, well, we're at a disadvantage because we provide our disclosures of what our experts are going to say. The state didn't. And then he's saying that, like, okay, well, I want you guys, provide disclosures and give more information than you need to. Okay? Then what's not that you need to, but like, give more information. That would be helpful in running my courtroom smoothly. But my interpretation from that was the state did not give disclosures. The DP motion was denied. Oh, so it's still on the table? Okay, gotcha. Okay. Alrighty. Well, guys, that was the end of day 2 of the hearing. And we'll see what else is up next. We'll see what the judge decides. If they decide to move forward with the Frank's hearing, and then if the IGG stuff gets suppressed, because if it does, then I don't know where we're gonna go from there. I don't know where we're gonna go from there. I feel like that's a lot of the state's case right there. So we'll keep an eye out. We'll see what happens. Now, I do want to cover, gosh, should I do it tomorrow? Corey Richards. Yo, Corey fucking Richards, okay? What's going on with Corey Richards? Let me see. Corey Richards. So I want to cover Corey Richards too, but maybe a different day. Corey Richards. Corey Richards' judge battles with attorneys over presenting facts in hearing. Also another judge that I like. Maybe tomorrow we'll do Corey Richards, I think. The judge is asking in open court and stream dates that are available for the Franks hearing. That's a positive sign he'll be granting a Franks hearing. Maybe.
We'll get.
I don't know. I don't know this judge well enough yet, I guess. So I don't know. I don't want to predict anything, but we'll see what happens. So maybe tomorrow we'll cover Corey Richards. I think so. I think tomorrow. Yeah. Man, there's so many things I want to cover. I think we'll do Corey Richards tomorrow. And then Sunday, I think we'll do second half of Sherry Frankie's book. That's what's on the agenda so far. I think we'll do that. All right, guys. So maybe I'll see you tomorrow. I know tomorrow's Saturday, but maybe I'll see you tomorrow. Maybe I'll see you on Sunday. And that's about it. Thank you so much for hanging out with me today. I appreciate you guys being here. Man, I feel like I have like so many video ideas that I want to do, but we're coming up pretty soon on our trip. So yeah, I appreciate you guys being here. Have a good one. About the disclosure, the state's okay. The state's deadline passed, but they didn't submit it, right? I heard that correctly, right? That they did not submit any disclosures for their experts. The defense just submitted theirs, I believe, today. Okay. All right. Well, we'll keep an eye on all of this. Yeah, the Corey Richards one, I'm really, should I watch it on my own first or no? No, you know what? I'm going to watch it with you guys. The Corey Richards one, we'll watch it together. Let's watch it together. Let's see. Corey Richards was in court Thursday for a hearing, which her attorneys asked the judge to consider suppressing evidence in her case. Throughout the hearing, though, both the defense and prosecution teams argued about several controversial pieces of evidence, including electronic data, video, documents found in Corey Richards' jail cell. At one point, the judge asked the attorneys to stick to presenting the evidence and the facts in the hearing instead of arguing about what should and shouldn't be allowed in the hearing and the trial. Yeah, I think we'll do that tomorrow. Happy Friday. Yes, happy Friday. I don't like Bird Box, the movie. It's very specific. Yeah, they didn't submit hardly anything for the experts. Man, it must be frustrating being defense attorneys. I mean, in this case, defense attorneys are like, well, we don't even know how they did the IgG stuff because whatever the feds did, that's secretive. And then not only that, we don't have the disclosures for the experts. Like, I don't know. Must be a very, very tough job being a defense attorney. All right, y'all. Well, that's about it. I hope you guys have a happy Friday. I hope you guys take care. I was like, should I do a Twitch stream today? I don't know. Or if I don't do a Twitch stream, maybe we'll just do Marvel Rivals on the side or something. I don't know, Jen, if you're around or something like that. Wait, the movie? Wait, do you hate the movie so much that you had to dedicate your username to I don't like Bird Box? I wasn't a huge fan of the movie either. Sustain. Hello, today's menu. How are you doing today? How's it going? So, yeah. Dude, I was hungry, but I feel like I'm not hungry anymore. Does that ever happen to you guys when you guys are like so hungry, but then you're so hungry that you're just not hungry anymore? Now I'm just like, I don't know if I feel like eating, but I should eat. I should eat. Maybe when I crack open the fridge, I'll get hungry. All right, everyone. Have a lovely Friday. Take care. I will see you guys later. Check out our past videos that we posted. We've been covering the Blake Lively versus Justin Baldoni stuff, and I think I want to do a video about that, but I don't know if I'm going to make the video before I leave. Probably not. Nah, I don't think so. Home from work. Ooh, chill yourself. I'm doing good. Doing good. To be honest, you were office drunk when I made my username. Well, you must really not like Burbugs. Bye, Nicole. Hi, Nicole. Bye, Siobhan. Bye, Salsa. Bye, Princess. Bye, Z's. Steph, thank you. Oh, thank you, Steph. You too. But I hope you guys have a nice one. And I would bring Shiro here to say bye to you guys, but he's sleeping over there. Lechon Mignon is just sleeping over there. That's my nickname for him. Lechon Mignon. All right, guys. Have a good one. Bye.